It's amended.
Yeah, Chair, we have got 473. You can start.
Okay, good morning, everyone. Thank you for attending our webinar for today, the 27th of March, 2024. This is a Code of Conduct webinar. It's an educational webinar. We'll be taking you through the Code of Conduct. So have your pen and a paper at hand. And then if you have questions based on the speaker, please just write it down. You can write it down on the chat, or you can just write it down on the piece of paper, and then we will have a session for question and answer, and then your questions will be addressed then. And yes, once more, thank you for attending. And also just to take you through our program today, there will be an opening by Mr. Ntokozo Masango, our SR Stakeholder Manager. And then from there, we will dig into our presentation. The legal team from SACAP will be taking you through the Code of Conduct. We'll be taking you through the complaints that we receive as a department, and then just to raise an awareness and so that you can also be able to comply with the Code of Conduct. So it's going to be a brief presentation, but what you can do, you can take questions down and ask them later so that you enhance your compliance with the Code of Conduct, because at the end of the day, we don't want to be receiving a lot of complaints. Hence, we are doing this educational webinar for our registered persons. So I will give the floor to Mr. Masango to do the opening and welcoming. Thank you, Mr. Masango.
Thank you, Program Director. To our Program Director, to our panelists, and to lastly to our registered persons. Ladies and gentlemen, on behalf of the South African Council for the Architectural Profession, it is a great pleasure that I welcome you to our webinar focusing on crucial topics of the Code of Conduct. Today, we gather visually to address common areas of contravention, aiming to provide evaluable guidance and support to our registered persons. And as we navigate through the program, we will delve into various vital aspects upholding the integrity and the professionalism within the architectural profession. From the importance of documenting the terms of appointment, for the significance of adhering to timelines. So each session promises insight that will enhance your practice. And our esteemed panelists here, experts in their respective domain, will lead us through this discussion. And additionally, we encourage active participation during our Q&A sessions. Therefore, we thank you for joining us today. We're wishing all of you a great session that will enhance your capacity. Thank you, Program Director.
Thank you, Mr. Masango. Thank you. We have to dig in and go into the program, and then we will be calling our first speaker that will be addressing the importance of putting your terms of appointment in writing, as well as the failure to perform work under mentorship. So our first speaker will be speaking to Rule 4.1, which I believe that as registered persons, we are all familiar with the Code of Conduct. And then also the first speaker will be speaking to failure to work under mentorship, which is Rule 2.6 of the Code of Conduct that addresses candidates. So I will be calling on our first speaker, which is myself. So the first presentation will be speaking to Rule 4.1. Then I'll just go to the rule. Okay, just to introduce myself again. My name is Kgaugelo Mashile. I am working at the legal department, and I'll be taking you through Rule 4.1 as well as Rule 2.6 of the Code of Conduct. So we understand that Rule 4.1 asks certain things from us as registered persons. For instance, it requires that before you enter into an agreement with a client or a member of the public, your terms of appointment should be in writing. But however, in the legal department, we are receiving a lot of complaints wherein registered persons are failing to formalize their contract between themselves and their client, in that they only have verbal agreement with their client. For instance, you will get a client saying that I want you to draw a plan for me, and then you will take that as an agreement. There won't be any paperwork whatsoever, and then you will start doing the work. So we are receiving complaints regarding this because you as registered persons are not formalizing your contract. You are just you are using verbal agreement, whereas the Code of Conduct specifically requests that before you do any architectural work, there should be something that is written down. And then the Code of Conduct even goes further to state that when you prepare that terms of appointment, there are certain clauses that you need to include in the agreement. So we do have registered persons that attempt to have their terms of appointment in writing. But however, their terms of appointment, they lack certain clauses as per Rule 4.1. When you go to Rule 4.1, I'll be referring to Rule 4.1 because I believe that as registered persons present here, we are aware of the Code of Conduct. If you're not aware of the Code of Conduct, just go and refresh and look at Rule 4.1 and see what is required in the terms of appointment, because Rule 4.1 specifically guides you as a registered person what you need to include in your terms of appointment. So we do have registered persons that they attempt to have their terms of appointment in writing, but usually there are certain clauses that they fail to put in those terms of appointment. So firstly, your terms of appointment should not be verbal, should always be written. So you must reduce whatever terms you agree with your client in writing. So have it written. You can even use a pen and a paper. You don't have to type it, but it must be written. So you must write it down. And then also when you write it down, there are certain clauses or there are certain provisions that you need to include in that terms of appointment. For instance, we receive a lot of complaints and we have prosecuted a lot of RPs for failing to put the certain terms in their agreement. For instance, RPs are failing to put dispute resolutions clause or provisions in their agreement. So dispute resolution is just to state that in case there's a dispute, this is the route we are going to take. So, but registered persons are failing to have that provision to say, in case of a dispute, this is the route we are going to take. So just take into consideration when you prepare your terms of appointment to include dispute resolution to say, in case there's a dispute, this is the route we are going to take. Are we going to an arbitrator? Am I going to pay you your money back? Is it going to be 50%? Those type of things. So you need to include them in your terms of appointment. And then also registered persons are failing to include termination clause. I know when you meet a client, you don't foresee that there might be a termination at some point, but the code of conduct requires that there should be a termination clause in your terms of appointment. So a termination clause just states that how do you get out of that agreement? So it's not necessarily saying that there's going to be a dispute, someone is going to terminate, but there needs to be an option for the member of the public, as well as for yourself as a registered person, that in case you want to get out of that agreement, this is the route you're going to take. This is the option that you're going to take as it's addressed in your initial contract. So when you type your terms of appointment, you must take that into consideration, because at first, yes, it's nice and rosy, but there might be an instance where you need to excuse yourself from that contract. So you are protecting yourself, and you're also protecting the member of the public to say that there's a termination clause. This is how you get out of the contract. So it's for you and the client as well. And then also what we've seen is that members of registered persons, they don't put their indemnity insurance clause. So in terms of the indemnity insurance clause, I just want to quote from the Code of Conduct, because the Code of Conduct specifically states what you need to write in your terms of appointment. So the Code of Conduct specifically states that you must give details of your professional indemnity insurance and include the following: the name of the insurer, the name of the insured, the amount of cover, the policy number, and the validity period. So if you write your terms of appointment and then you don't include this number of things that I've just stated, and then it happens that someone complains against you at SACAP, and then it lands in the legal department desk, what the legal department will do is that they will go to 4.1 and look at your terms of appointment and check if all of these things on 4.1 are there on your contract. And then if they are not there, then you might be found guilty of a misconduct. So just go to 4.1, just make sure that your terms of appointment mirrors what is on 4.1. So that will be it on 4.1. And then also what you need to take into consideration is that SACAP has made an attempt to make sure that registered person complies with Rule 4.1. For instance, there is 2 types of contracts that are on our website for low complicity as well as high complicity projects, to help you as a registered person to comply with 4.1, because we have seen that perhaps maybe you might need an attorney to help you draft the terms of appointment, but SACAP has made an attempt to make sure that you comply with the rules. So there is a template that is available for you guys on the website to use. So utilize that, because now you don't need an attorney anymore. There's a template that you can use. Use that template, and if you use that template, you will forever be compliant with Rule 4.1. Irrespective of how long the document is, use it, because it's going to help you, it's going to protect you, as well as protect the next person. So we are receiving a lot of complaints on 4.1. So that's why there is even an attempt from SACAP to make sure that there are templates available for you, registered persons. So make sure that you use the template. And if the template is a large document for you, just make sure that your letter of appointment mirrors what is on 4.1. So yes, so that will be it on 4.1. I believe that if there's any questions, you have written the questions down, and then there will be a session for that. So the next topic is Rule 2.6. Rule 2.6 is for candidates. It's just to state that if you are a candidate, you need to always work under supervision. So if you are a candidate, you always need to be under supervision. So it actually, what is required in terms of Rule 2.6 is that there need to be someone who takes responsibility for your work, because there's a reason you're a candidate. So it means you are not ready to be exposed to the industry yet. You still need to be trained. You still need to be supervised. Someone needs to hold your hand. But surprisingly, we are receiving complaints at the legal department where candidates are working independently. They are working without supervision. So, and it poses a danger to the society, because now someone is out there who's not competent. Someone who's not competent enough is doing architectural work. So we are receiving a lot of complaints on those instances where candidates are independently working without supervision. So what we do when we receive this type of complaints, we usually send an email to the mentor, because before you register as a candidate, you should have a mentor. So we send an email to the mentor to inquire if they are aware of this certain project. And in most cases, they are not even aware. So that it means that the candidate is working independently without supervision. So what we do then is that we charge the candidate with the contravention of Rule 2.6. And this is actually, it leads to incompetent work. So now there's work there, outside there, that is being completed by someone who's not competent. So now, and then usually there's an unhappy client behind all that. And then now clients will lose money. So we just want to say that if you are registered as a candidate, please always ensure that you are working under supervision. Just make sure that you work under your mentor. Your mentor always knows that there's a project that you're working on, because your mentor needs to supervise you. Because at the end of the day, there's a reason you are a candidate, is because you are not competent enough to independently work on your own. And then, however, we also have this type of complaints from against candidates where they misrepresent themselves. So you'll be registered as a candidate, but outside there, you present yourself as a professional. For instance, you are registered as a candidate architect, but when you introduce yourself to the members of the public, you refer to yourself as an architect. You see, now it's a misrepresentation. So which is also against the Code of Conduct, Rule 3.1, which says that you must, when you present your work, you must be honest. So now if you are going outside there, you are introducing yourself to the members of the public as a professional architect, where else you are a candidate, is a misrepresentation entirely. So this actually brings the professional into disrepute, because now you are misrepresenting yourself. You are giving the impression that you are competent to do certain work while you are not. So if you are registered as a candidate, just stick to your profession and write the exam and be a professional, so that you can be competent to do the work, so that you can be competent enough to introduce yourself as such. If you are a candidate, introduce yourself as a candidate. There's actually nothing wrong with being a candidate. It's just saying that you are still under training. So if you are a candidate, please present yourself as one, because if you are found to be presenting yourself and misrepresenting yourself, you will be found guilty of a misconduct. And you don't want to be found guilty of a misconduct while you are still under candidacy, because it doesn't reflect very well on your career entirely. So yes, so I believe that if there's any questions, you are noting them down, or you are writing them on the Q&A, they will be addressed later. And then as I'll be handing over back to the program director, which is myself, and then we will move to the next speaker. And then thank you for listening to my presentation. And then I believe that you have learned a lot, as I've also learned when I was presenting to you, that you have taken notes, and then you will improve in your compliance with the Code of Conduct. because the code of conduct is also there to protect you as well as to protect the members of the public. Because if you comply with Rule 4.1, as a registered person, you are not only protecting yourself, you are protecting the people you are doing business with, because there will be certain clauses that are being addressed in protecting them and in protecting yourself. So we will move to the next speaker. And then also just to emphasize on Rule 2.6 is that if you are a candidate, you need to present yourself as such. It just means that you are under training, and then you will be a professional eventually. You will be able to independently work on your own, and then now you are still under training. So just stick to that, and then you will be better off next time. So our next speaker is also from the legal department. He's been with us at the legal department for quite a while, and then he's been exposed to the type of complaints that we received at the legal department. So he'll be taking you through some of the complaints that we receive as the legal department, and then just take notes, because if you can avoid this type of complaints that we are referring to here, it means then you will be in compliance with the code of conduct. So take notes, and then I'll be calling on Mr. Ntanganizeni Makakabule, who will be taking us through the next few presentations. Just bear with us, take notes if you have to. If there are questions, write them down, and also we will be able to address them later on. Yes, thank you. Then I'll take the floor to Mr. Ntanganizeni Makakabule. Thank you.
Thank you. Just want to share the screen. Thank you. Good morning. My name is Ntanganizeni Makakabule. I am part of SACCAP. I am in the legal department. I am a legal compliance officer at SACCAP. So yes, I've been with the company for quite some time now, with the regulatory body for quite some time now. So yeah, I'll be taking you through my presentation, and I'm sure you are going to find it interesting and very valuable for your day-to-day work in the practice. And yeah, I'm sure this will also assist the registered persons wherein you had challenges. Now you'll have a clarity on how to handle some situations that you have had with the members of the public, with your clients, or even with other registered members. So it is quite important to take note, as the previous speaker has indicated, wherein we will be now aware of how we should carry ourselves, and also it will also assist in the number of complaints received by SACCAP, because what we're trying to do here is trying to assist you to comply with the code of conduct, and also by complying with the code of conduct, it means that we will not have complaints, and even if we do have complaints would be dismissed based on the fact that our registered members have complied with the code of conduct. So my presentation will be focusing on poor communication with clients. So this will be the start of my presentation, wherein we're saying that registered persons shall ensure that after each milestone, the client signs off where the scope of work involves more than one stage. So let's say you have from stage 1 to stage 4.1. After every milestone wherein you have undertaken work, at least by communicating with the client, by informing the client of such a milestone that has been completed, you may want to make sure that you put that in writing, or it's an email of confirmation that such work has been done. Because sometimes when matters comes to SECAP, the member of the public or your client will be saying that, no, I appointed this registered person to do this and this, but then he has not done any. And then according to you and according to what you have done a lot. And obviously this what is this saying of saying that the customer is always right? It's not always right. I don't know, maybe in consumer, maybe in other businesses, but sometimes for you to protect yourself, when you know that, no, well, I have done the design, I've went on site, this is what I've done. So keeping records and informing them of what you've done, it makes it easier wherein they have confirmed. Because when it comes to SECAP and the client is alleging that you have done this or you have not done this, you'll be saying, no, hold on, look, here is what we have done. I have communicated with you. I have informed you of what I've done at this point, and then here's proof. You have confirmed that, and then we moved on. You gave me authority to do this, and then we move on. Because at some point we are putting this on, because you would find that there's a situation where you go meet a client, and then after that you know what to do. The design is there in your mind, or however you've gotten the scope, and then off you go. And then the client will be now calling SECAP, no, I've appointed this guy 6 months ago. He is not responding to me. He's not giving me any feedback. I've paid him what he required. So now that cannot be said to be professional, because by you keeping him or her informed, it means that you are doing your job, and then he is encouraged to have you as a professional. So the rule extends to informing clients in writing of any issue which may significantly affect its quality or cost, and any other consideration which may substantially affect the project. So now you might have a situation where you have had, let's say you submit the plans to the municipality, you've prepared the plans, you submit them to the municipality raises questions. Okay, fine, there's amendments that needs to be made, the corrections that needs to be made. You do not inform your client, and then it takes a month or two, and then the client now wants, because sometimes they'll probably even start building. But then now when they're being issued with fines, they now start saying, no, let me go to the municipality and check what is going on. They go there and they find that, no, you have been issued with an amendment letter. You have not attended to that, and then you have not informed them. They then come to SECAP, no, this, because it'll be clear. Once you get a communication that needs your client's attention, please inform your client so that he or she knows where you are in the project and how are you going to be dealing with the project. Because after someone has paid, it then becomes your responsibility to inform them of what is going on your desk. So these rules assist the registered person in keeping track of their milestones on the project, and also assist whereby the client alleges that such work has not been done, and such proof can be produced to confirm performance of such milestone. So this is what I was indicating earlier on, to say, no, if you are informing them of this, then they've consented to that, not necessarily consenting, or they have been informed, then you can say, no, I've informed this client on this date of such milestone that I had accomplished, wherein I was appointed to do. So we also have signing of plans by clients before the plans are submitted is also important, as it also proves that the client has been seen the plans and have proved them as they are to be submitted. This provides the client with courage and transparency with the work during the project. So sometimes you might find that a client can come and say, no, look, I appointed this guy to prepare plans for me in this way, but however, he has prepared them in this way and has submitted them. This is not what I wanted, right? So when you have a situation where you have completed your drawings as per your scope, you let the client see, inform the client signs off to say, no, this is what I've what I've asked the registered person to do. So then that will be proof, because we have had complaints wherein complainants have indicated that no, he's prepared a wrong scope of work. I did not ask him to do this. You understand? Because anything can be said. Anything can be said. We've had a lot of complaints. Some were even surprising. But if you have a plan which is signed off by the complainant or by your client, it then serves as proof. To us, we now take it as if the client has seen the plans and has consented to them being submitted as they are. Then that means that you have executed your mandate and your scope of work. This is what the client has asked you to do. Yeah, you understand. So we also have registered persons often fall victim to this rule by noticing significant changes in the progress and not informing their clients. Budget gets exceeded and clients are left to feed the bill. It is important to inform the client of any of this and let the client be aware and make reasonable and informed decision on the matter. To avoid he said, she said, she situation, it is required that registered person keep their clients informed in writing to prove that this was indicated to the client and this was the client's response. So now, where you have a he said situation, it becomes now your word against your client, and then that is not a situation that we want to have. Wherein we want our professionals to attend to their work professionally by indicating, no, this was done on this day, and then this is what we have done. This is what the client had indicated, and then now she or he cannot come back and say, no, this is not what I had said, or this is not what I had requested. So it makes it easier. Keep your clients informed in writing would be best, so that you can be able to produce such a response. However, even call logs, because what the rule requires is that you need to keep your client informed. However, in writing, it can be best. Even calls, they can indicate that you have been communicating. WhatsApp, I mean, if you can produce evidence of such, then it's sufficient, because what we want is that we want our registered persons to make sure that their work is done professional. So we move on to the next slide, wherein on this part of the presentation, we have a situation where we have noticed that registered persons are renting out or lending out their registered numbers, or their registration numbers, to either unregistered persons or to other registered persons who might not be able to perform such work, and because they are in the position to perform such work in terms of the identification of work, they then rent out their registration number to the said person. It could be registered or unregistered. So what we're saying on this presentation is that registered persons shall only issue drawings, specification, or documents in respect of work performed or administered by them or by the person in their employee which bears their name and or registration number or the name of their architectural practice. So we're trying to make sure that whatever work that you put your registration number on is performed by you and not by any other person. However, it is if you are in a company and you own that company, the work that has been performed in your practice must have your registration number. That supports your responsibility to say that you prepared this work, and then that work has been prepared in your office, and you are the registered person on that on those plans. So this rule has been widely contravened unethically by registered persons, whereby we have had complaints of registered persons signing off on unregistered persons' work and unqualified registered persons' work for submission. So you'd find that in certain complaints, we receive complaints wherein a registered person is signing off unregistered person's work. So that is a professional misconduct. You know that this person is not registered. But because of your association with him or whatever, obviously it can be monetary. You will then be signing off this person's work, and then you know that he's not registered, and then you are the ones who are paying annual fees. So what we're trying to do is that we're trying to preserve architectural work to only be performed by registered persons. So if you decline that proposal by that unregistered person, it means you are giving your colleague who is registered work if you're not taking it yourself. So we're trying to move away from unregistered persons performing work wherein the work is not even up to standard, because unregistered persons do not have what is this? They do not have the identification of work, so they do not know where they fall under. They will just take on whatever work that is presented to them. They're like, I can do it, and then put your registration number there. When a complaint is lodged, we then follow on the registered person whose registered number is on the plans, and then it is you. And then there's a rule wherein we will then have to find you. We will then have to investigate, and then we might find you guilty of professional misconduct, wherein you have rented out or you have signed off some other person's work that has not been performed by you or under performed in your office. So other registered persons have complained that because of them being of a low category of registration, registered persons make them pay hefty fees for these signatures, and we have taken them to task. So you'd find that this person maybe is a draftsperson, and then you're you're a professional architect, and then you then say, no, I will be then sign off your work. That is not allowed. You must only put your registration number on the work that has been performed by you, and then complain. Other registered persons have complained to say, no, look, there is Steve who's charging me 10,000 rand. Because I am a lower category, and in terms of the identification of work, I cannot perform such work. So for me to submit, I have to pay the hefty fine, the hefty fee, so that he can sign off. And he's basically doing nothing. He's just renting out. That's unethical. So we're trying to caution our registered persons, please move away from that. Only sign the work that has been performed by you or under your practice. We often see the contravention of this rule where registered persons sign off copied work that belongs to other professionals, making that work theirs and submitting such work to the local municipality for approval. This conduct is not only contravention of the Code of Conduct, but it's also contravention of Copyright Act, and registered person can find themselves being sued by original authors. So you might find yourself, because we have had complaints wherein other registered persons have been taken to court because they took some other registered person's work, and then they did not inform the other persons that they are putting that they are taking over such work. So please be careful on copyright. Please be careful on intellectual property. Please. So this rule actually it's trying to say, let's only put our registration numbers on the work that we have performed or that has been performed under our practice. On the next slide, we have, let me just move this so that I can see. Okay, so here we have registered persons shall attend to all corrections requested by the local authority on the drawings prepared by them within a reasonable time. So on this rule wherein we are saying that registered persons have failed to attend to corrections requested by the local authority, we have seen that plans are submitted to the local authority, to the municipality. However, registered persons have failed to attend to those corrections, and then they have failed to do that within the reasonable time. Plans are submitted on a local authority on a daily basis, and having them refused by local authority is not a misconduct. However, failure to attend to such comments within a reasonable time is. So when there's corrections that are needed and you have failed to attend to those corrections, reasonable time will be your enemy. So we will have to look at the reasonableness of the time that you have taken to attend to those comments, or the time that you have not taken to attend to those comments, because the client would want to be, let's say, built, or however, if the house is being sold, he wants to sell the house, and then he is depending on you to provide the approved plans, but you are taking unreasonable time to attend to the corrections, and by taking that time, it means that you are delaying the client on his and or her objective. So on a regular basis, we receive complaints from the members of the public with regard to this rule. Registered persons submit plans and do not follow up on the progress of the plans for months, if not years, after being paid for such service. Members of the public will be calling to lodge complaints, seeking SECAP to assist them with following up with their appointed professionals to attend to the corrections made by the local authority. Registered persons are once again urged to make follow-ups with the submitted plans, as in most cases, these corrections and or amendments are sent to them, and only they can attend to these corrections, as the client cannot perform such. So now, what will be required by the municipality will be something that even the client cannot do. Only you as a registered person must attend to. You'd find that maybe they want sometimes, okay, fine. If maybe it's a title deed, it does not mean that the client should submit, saying you should be able to have received the title deed and looked at the restrictions that are required, that have been indicated there on the title deed, and then when such is requested, you must be in a position to submit such title deed to the municipality. Corrections will be architectural in nature, so the client will not be in a position to submit those. So those corrections will then be on your professional responsibility to correct timeously. We have noticed a trend with registered persons using fraudulent stamps. Okay, so this is another presentation wherein we have noticed that registered persons have I don't know, but obviously it will be in their own reasons wherein they have used municipal stamps to purport the plans to be approved while the plans are not approved. So we have noticed a trend on this, wherein registered persons are using fraudulent stamps purporting that the plans have been approved while they are not. It is not only a professional misconduct, but also a punishable criminal offense. Registered persons are urged to conduct their service ethically to avoid any act that has the potential of rendering their conduct unethical. Complaints have been submitted to SECAP where the homeowners applied for a building contract with the bank and submitted the same plans to the bank for approval, only to find out when the municipality serves them with a letter of a fine for building without approved plans, that there is no approved plans on the municipal system. The plans provided to the homeowners was fraudulently stamped by the registered person, who now faces legal action by the homeowner and the criminal charges to that effect. So I obviously one of the reasons that they would do that is to make sure that the client maybe sees that the plans have been approved, because we have a lot of complaints on that, wherein registered persons, not only unregistered persons, of which it can be fraud, it can be forgery. You can find yourself in very hot water, and for you to be then be registered again with SECAP, you might not be registered again with SECAP, and this is your livelihood. You might not be registered again with SECAP, because SECAP prohibits certain persons from being registered with SECAP after such has been after if you have been found to have been guilty of fraud or forgery or other acts. So you will then be deregistered and working without being registered with SECAP. As you will hear on our next slide, we have been reporting such cases, and we have a lot of cases that we can report on, wherein we have convictions of people who have been practicing architectural work without being registered. So let's practice ethically. Let's not, if a plan is not approved, a plan is not approved. Let's not use fraudulent stamps to stamp on it, because you will be found. The municipality will then have to come to SECAP to say, no, we have had these plans, this is the registration number. When we communicate with the complainant, who is the homeowner, she will say, no, I received these plans from this registered person. And that on its own, it's a criminal offense wherein we have referred such to the SAPS for investigation and prosecution. So let's not, let's try to get the plans approved. Let's comply with the requirements and the laws that the municipality will be indicating to us to comply with to get our plans approved. On the next slide. Okay, then that will be all on my presentation, and I will leave it to the program director to assist on who will be next on our presentation. Thank you so much for your attendance. And then, yes, I've noticed that there's a lot of questions regarding the attendance, the CPD, on the chat section. That will be attended to, and then you will be responded to, because I've seen that it's mostly the same question that I am. Tom, Steve, I have logged in. Please, can you allocate my CPDs? Those will be attended to, and you'll be informed. Thank you so much. Thank you so much for your attendance. Thank you.
Thank you, Mr. Makakabule. What a mouthful. What a mouthful. We have so much to digest, so much to take in. I hope you are taking notes. I hope you are taking notes, and yeah, I think I'm getting an echo. Just okay. I hope you are taking notes and you are improving yourself as we go, because as I've said in the beginning, this is an educational webinar. We are here to educate ourselves because we want to improve ourselves in how we provide the service to the members of the public. So thank you so much, and thank you so much to Mr. Makakavole. I believe that we have learned a lot, and also we have improved as we go. And then because we've been sitting down for since 9 o'clock, and then now it's 9:47. So I will, because there are some people who smokes, because I don't want anyone to miss anything. I want you to be able to take notes as we go on each and every speaker that will be taking us through their presentation. So there will be a question and answer now for the first 15 minutes, and then there will be a body break after. So I just need to find out from Mr. Masango how we're going to take the Q&A after Mr. Makakavule's presentation. Thank you.
Thank you, Program Director. You can take hands. We will allow attendees to speak, and we'll also check a few questions on the chat that we can respond to. So you can allow attendees to raise hands. We will allow them to talk from our end. Thank you.
Thank you, Mr. Masango. So if there is any question, the question should be based on the presentation that have been presented now, and then you can raise your hand, and then we'll allow you in to ask your question, and then the speaker that presented on that topic will then come in and assist you on the answer. So we will allow registered persons to ask questions, and then the questions should please be limited to the presentations, so that we don't want to, I know there might be a lot of questions, but let's just limit our questions to the presentations. If we have questions that have not been addressed, you might be surprised it might be addressed in the next presentations. So for now, let's just limit our questions to the presentations that have been presented already.
Thank you, Program Director. We will allow Darius, John, Anat in that order, please. Darius, you can unmute. think while Darius is still trying to unmute, can we go to John? John Lewis, you can unmute. Darius, John, you can come through. Okay, can we then go to Arnott?
No.
Yes,
Yes,
there
you
we
can
go.
come through.
Hi, thank you very much for this webinar, very informative. In the event of, for example, a professional senior technologist bringing in a project which is above the reserved for qualified architects, and the qualified architects decide, yes, we could work jointly on that, right? Are we then allowed to sign the contracts as an architect and also as a professional senior technologist? And also, are we allowed to display both our names on the plans? Obviously, you know, we will have an internal agreement, but from SACCP's point of view, I'd like to have some clarification.
Okay, may I? Okay, in terms of the terms of appointment, because we're also taking into consideration the identification of work. So if you have an agreement with a professional architect and then you are a technologist, and then you want to do a work that is reserved for professional architect. So on the agreement, it needs to show both your names because the professional architect will be taking responsibility for the work that is reserved for a professional architect. So on the agreement, it should show both your names. Even on the plans, it should show both your names. Thank you.
Thank you very much. Can we also do, when it comes to the professional indemnity insurance, you know, do we now, obviously it depends on us whether you want to carry the professional indemnity insurance independently or can that be done jointly?
Okay, I believe that will have to be a discussion that you'll have to have with your partner who will take a responsibility in terms of the indemnity insurance. So you will have to discuss that. But for the sake of the amount of cover, I believe that the professional architect should take responsibility because of their competency, and then they might have a higher cover compared to you as a technologist. So it's just a discussion that you and your partner will need to have.
Thank you.
Okay. Next question.
Can we then allow John? We'll allow John and Saba in that order, please. Saba, you can unmute.
Yeah, I think they're struggling.
Good morning. Am I audible?
Yes, you are.
Okay, thank you for this opportunity and thank you for the much insightful webinar. So my first question is, I think the previous presenter had mentioned that you as SACCP, you're basically trying to preserve work for registered persons, right? But you quite often find that there's unregistered persons who practice using the credentials of a registered professional without their consent. And how this normally happens is that our professional certificates, registration certificates, they've got a barcode, right? Which one can scan and retrieve a clean certificate that they can operate from, and also sign on drawings and sign on those SANS 10400 forms that we used to submit to the local authority on behalf of the registered professionals without their consent. And my concern is that, how is SACEP policing something like that, or situations like that? Is there some kind of a policing system? Thank
Okay.
you.
Okay. Okay. So in terms of your question, there is a specific presentation that is going to be focusing on that. I don't know if I should jump the gun now and address it, but there's a specific presentation, there's a specific presenter that will be focusing on those type of things. I don't know, maybe let's just wait a little bit because there's going to be a presentation on that.
Okay, thank you. I'll wait.
Okay.
Thank you, Saba. Can we have Mr. Mohammed? Mr. Mohammed, you can unmute.
A person renting out this professional number.
Mhm.
Can you hear me?
Yes, we can hear you.
A professional renting out this number to other people to draw on this number. Could you elaborate on the consequences and fines on that, please? Thank you.
Okay. Thank you. Thank you for the question. So if we find that you as a professional, you are renting out your professional number to someone who's not registered to use it, there is you'll be found guilty of a misconduct, because what you're doing is that you are bringing the architectural profession into disrepute. So you will be taken through the whole process of the matter being investigated. And then after being investigated, the matter will go to what we call a tribunal, or maybe a disciplinary tribunal. So in that disciplinary tribunal, they ask 4 consequences that you can face. Is your registration as a professional can either be cancelled, or it can be suspended, or you can be cautioned, or you can be fined an amount of over 20,000 rand. So based on the seriousness of the offense, those are the sanctions that can be preferred against you as a registered person. So it will have to go through that whole process, and then you can face those four sanctions against yourself. Thank you.
Thank you, Mr. Mohammed. Are you covered on that one?
Thank you so much.
Thank you. You're most welcome.
Thank you.
We'll allow Robert. We'll also allow Mr. Ramlal. We'll also allow Rufaro Jwamba in that order, please. Robert, Mr. Ramlal, Rufaro.
Good morning. Thank you very much. I have a question relating to the discussion at the beginning of the webinar about candidates acting as professional architects. But I'd like to ask the question the other way around. If a candidate registered with SACAP gets promoted to professional architect and is registered as a professional architect at SACAP, what are the consequences of that person continuing to stay as a candidate with the voluntary association, primarily because it is a cheaper membership fee?
Okay. I don't okay, maybe I don't understand your question, but in terms of our rules and our policies, a candidate can only stay as a candidate for 4 years. So if you are a candidate and then you present yourself as a person who's a professional architect already, then you will be, and it happens that SACAP finds out, then it is going to be a misconduct, and it is going to be a dent on your career, because we are required to publish those findings. So in terms of the VAs, if you are registered with a VA, it does not necessarily mean that you are registered with SACAP. So you can be registered.
Sorry.
Yeah.
Sorry,
Okay.
you've got the wrong end of the stick. You
Oh,
have a
okay, yeah.
person who is registered with SACAP as a
Mhm.
candidate and
Yes.
gets promoted to a professional architect.
All
So they
right.
are registered at SACAP as a professional architect.
Okay.
They are registered with a voluntary association,
Mhm.
originally as a candidate, and they don't upgrade their registration at the voluntary association to the professional level. They remain as a candidate primarily because the fees, the membership fees, are lower. What is SACAP's response?
Oh, okay. Okay, no, I
Sorry.
think now I understand. I thought I didn't understand at the beginning. Okay, because with us, if you are promoted to a professional architect, you will be required to pay the fees for professional architect.
Yeah.
So what happens in VAs, SACAP will not be involved. If at the VAs you remain a candidate, at the SACAP you stick to your professional upgrades, then SACAP will be fine with that. But with the VAs, SACAP will not be involved.
So being fraudulent misrepresentation does not actually count, does not worry you.
No, because now you are misrepresenting yourself there at the VAs, then it will be against Rule 3.1. You see, okay, Rule 3.1. Okay, should I read 3.1 for you?
That's all right, ma'am. I'll look it up. Thank you very much.
Okay.
Mr. Ray Ramlal, and then Robert, then Rufaro.
Morning, Chair. Thank you very much. Excellent program. I just want to refer to the code of conduct versus the contract. And earlier you elaborated on basically the availability of a template on the website. I'd just like you to please help the members on, whoever is on, just to get an idea, better idea as to how important the template is that's provided by SACAP, that will hold their hands together when they're doing work on the correct side of whatever duty they are contracting with. And I think it's important. I bring this point up because I think whilst we're bringing up the code of conduct and with SACAP making this template available, how important it is from the professional side and to work together with SACAP. Thank you.
Thank you. The template is available on the website. It's you go to the website sacapsa.com. It's available under for the public. It's called client agreement. You click there, and then once you click there, you will be shown two types of agreement. It's a low complicity as well as high complicity agreement. So you can use that agreement whenever you come across a client. So the reason SACAP developed that template was to enhance compliance, because we have seen that we are receiving a lot of complaints against the registered persons for non-compliance with Rule 4.1, and then hence SACAP made effort to ensure that the registered persons comply with Rule 4.1 by developing templates. So that is just to enhance your compliance. Yeah, thank you.
Thank you.
Thank you.
You're welcome, Mr. Ramlal. Mr. Rufaro Chambwa, please come through. After Mr. Rufaro, can we have Teboho? Mr. Rufaro? Okay, can we take Teboho? Then after Teboho, we'll take Francois van Donder. Teboho, you can unmute.
Okay, thank you. Can you hear me now?
Loud and clear.
Oh, yes, I can hear you.
It's Francois here.
Thank you.
Thank you for the opportunity to talk.
Mr. Francois, can we allow Tebogo first, and then you'll come after him?
Oh, apologies. Thank you.
Thank you.
All right. My question is, so I am a kind of a manager at in an organization where I've got people working under me, and some are not registered, and they do mostly interior work. So the attitude they're having is they see no need of being registered candidates or professionals. However, I just want to confirm my view is that if you're doing any work of this nature, regardless of where you are or under somebody, you should be registered at least as a candidate. Is that a correct assertion? Thank you.
Yes, yes, it's correct. If you are doing any sort of architectural work under someone, you need to be registered. Because when you look at the code of conduct, I'll refer you to rule 4.6, because for them not being registered, they're actually putting you in danger. Because in terms of rule 5.6, it says that in order for you to work with people who are not registered and they're doing architectural work, you should ask for permission. So if you want to work with people who are not registered and they're doing architectural work, you should be asking for permission. So I will encourage you to encourage them to register so that you avoid being in contravention with Rule 5.6. You can just go read on Rule 5.6 and then you will see what I mean.
Okay, thanks very much. That's it.
Thank you. Thank you.
You're welcome, Mr. Tebogo. Can we then allow Francos van Tonder? Francos, you can unmute.
Thank you. Can you hear me?
Loud and clear.
Great. Thank you for the opportunity. My question is maybe more of a remark or some feedback rather than a question. But in terms of the time that is taken to get plans approved, what was the term that I'm looking for now? Maybe I'll get to it just now. It's just that the struggle with some of the municipalities or building control officers is that they have very limited time for consultation, and then you would find that some of them would cut off the line at a very early stage in the morning, which makes it very difficult for one to actually go and discuss certain applications with the plan examiners. And then also, some of the guys or municipalities won't accept a runner or a representative of the office to discuss certain items, and they will require the professional's personal attendance. And to sit in those rows for hours at a time, I mean, I don't want to lift or point at any specific municipalities here in Gauteng, but it is a Gauteng issue, is that we will then have to sit for 4 to 5 hours. So my question actually would be, is what would be a reasonable time to get a plan approved after the municipality is just not accessible? It's quite a frustration, and I do understand that clients would come back and ask for feedback, and it's sometimes very difficult to give them feedback within a reasonable time because the municipality is not reasonable in their availability. Please, can someone give me guidance in that regard, please?
Okay. I will be referring to other parts of the code of conduct. So you just have to bear with me and then just have to go and look it up. Because in terms of a reasonable time is subjective to whoever you are. So what you need to do as a registered person or as a service provider to a client in terms of Rule 4.14 of the Code of Conduct, you need to always inform your client that I've went to the municipality, this is what they've said. Because in that way, you are covering yourself as a registered person, because the complaints that we receive at SACAP, we receive them from members of the public or your clients complaining that I don't know what's happening to my plan. It took forever for them to be approved, because usually they're in the dark. They don't understand, they don't know what you as a professional you are doing in the background. So what I can advise you, because the municipality might take forever to get your plans approved, but what you do as a professional, you inform your client of every time you've done an attempt at the municipality, you inform your client of everything you've done, and then you do so constantly. If you can do it on a week-to-week or a month-to-month basis, is better in that way that your client is always informed of what's happening. And then they're unlikely to send a complaint to SACAP to say that it took forever for Francis to get my plans approved, because it's not you who approves plans, it's the municipality. So if your client is aware what's happening, I think that it's unlikely that they'll send a complaint to us.
Thank you very much. I appreciate that.
Thank you.
You're welcome. Program Director, you will indicate to me based on your time. I don't know if we can take last few hands, or we break. Maybe we can take a few hands more.
Yes, we can take two last questions, and then we break for a body break, and then we'll continue with our speakers. Thank you, Chair.
All right, thank you. Can we have Tsepo, and then after Tsepo, we'll have Honesty Ndo. Tsepo, you can unmute.
Thank you very much. Good morning. Am I audible?
Yes, yes, you are.
Thank you very much. Good morning once again. What I would like to find out, I work in the public sector. My question is related to the standard contracts for professional service providers. The standard contracts that were presented earlier on, have they been tested for compatibility with your normal supply chain standard documents? Can they be accepted, and have they been tested to be acceptable by your Auditor General and the likes? The reason why I'm saying this is because you will find that generally in the public sector, there is no established, at least where I am, there is no established really format, if you say, as we would compare with contractors and the JPCC, NEC and the likes, when it comes to professional service providers, particularly because the PROXA contracts are not really accepted. Thank you very much. I'll wait for the answer.
Thank you. Thank you so much, sir, for the question. Look, our contract has options wherein if a certain clause, or if a certain aspect or a certain part of the project is not included in your agreement, or maybe if I can say, if it is not applicable, you can cancel it out. However, what we have done is that we have put out the clauses that needs to be complied with on the Code of Conduct. So this is how I'm going to respond to it. So you can draft your own contract. However, your contract must comply with the clauses as set out on Rule 4.1. So what we have done as SACAP is that we have noticed that some professionals do not have maybe the fees and or time or the know-how on how to draft these contracts. What we've done is that we have prepared our own, and then we have put them there for registered members to go and download and be able to use. So if you can produce your own contract, you can do that. You are welcome to do that. However, your code of conduct must comply with the clauses set out there on Rule 4.1. So it does not, we were not saying only use our contract. You can use our contract which complies, or should you have other clauses that you need to include, you can then formulate your own and use it as long as it complies with the clauses set out in 4.1. I'm sure that will answer your question. Thank you.
May I just make a follow-up? Should I proceed? Sure.
Yes, you may proceed, sir.
Thank you so much. Yeah, that does not necessarily answer the question, but what I think maybe needs to happen, because I get the sense that there might have not been really an effort to test it, to rather make the contracts consistent with what the state expects. We are experiencing, within the public sector, we're experiencing serious trouble with the Auditor General, where they are finding that we cannot account for what the professional service providers, in this case architects, do, and how they are contracted and the likes, purely because there is no standard way of doing it, and historically it's not been happening. So now that we're on a drive to ensure that we use standard contracts, and the rule is very clear about how one should do that, I think as the state, because SACEP is the state, together with the Office of the Procurement General, there must be some meeting of minds to say this is what we are accepting as a standard contract that can be used in the state, so that we don't leave an option for anybody to do their own contracts necessarily, but contracts that comply with SACEP and the profession, together with what the state expects, so that they're able to pass that litmus test with the Auditor General in order for projects not to be found to be irregular. Thank you very much.
Okay. Okay, thank you so much, Mr. Tepo. So we will actually would like to explore that. You can perhaps send us an email at legal@sacapsa.com, and then we can see how we can close those gaps. And thank you so much for bringing that up.
Thank you,
Okay.
Program Director Tepo. I'm not sure if you are covered on that one. I'll take it as covered. Can we then have
yes, thank you so much. I'm covered. Thank you. Cheers.
Super, thank you. Can we have the last question from Honestine Doe? You can unmute.
Good day, colleagues. My question is around registered professionals that have got candidates that are working under them, where they keep them too long as candidates by not signing their MTR, so they keep them under their employ. Is there any consequences with that from SACEP side? Because if you look, some candidates, a candidate is someone is a candidate for like 6 to 10 years because their MTR not signed, so they can write the exams. Is there any consequences in that from SACEP side? If you can respond to that, I'll be appreciated.
Okay, so I'll try my best to answer that, because that should be addressed to our education department. But I believe that in order for you to write the exam, you don't need your MTR to be signed. So you can write the exam, and then when you upgrade, then that's when your MTRs will be signed. So if you have anyone who's being whose principal is doing that, I think we should bring that to our attention, because that's just been called. So you need to bring that to our attention so that it can be addressed, so that that principal can also be addressed, because now they are withholding the professionalism, and then they are bringing the architectural profession into dispute because they are holding candidate hostage. So I think you need to bring that to our attention, the specifics, so that it can be addressed. Thank you.
Yeah, Thank you. But what happens is that when you upload the MTR, your mentor is supposed to sign them off in order for you to be able to book the exam with the Ricky. If they're not signed by the mentor, you can't write the exam. So that situation is that you find a candidate got so many MTR points, but they are not signed off by the mentor because the mentor wants to hold them hostage. I was hoping that maybe SACEP is checking maybe some candidates that are staying for too long as candidates. What is exactly the issue? Because that is very common in the industry.
Yeah, because I've said in the beginning, I'll try my best to respond to that. I think that the best way will be for you to email Ricky and address that with the education department, because I believe that there will be better people to address it because it's within their work. So I'll humbly request you to send an email to Ricky.
Okay, thanks a lot. I think you've answered me. The reason I'm raising it because I was a victim of that and I was assisted by after many years. So yeah, I'm just raising because it's a very common thing and I've never had anyone talking about it. So thanks a lot.
Thank you. We'll note it. Thank you.
I'll then give it back to you, Program Director, and the hands that are still raised on our attendees list, please be rest assured that your questions will be taken on our next Q&A session.
Thank you. Thank you. Okay, now I'm back to being a program director. Thank you everyone for your questions. I hope you've been responded to, and then you are satisfied with the answer. And then now it's exactly 10:21. So I would like us to take a body break. Let's go have a smoke. Let's go to the bathroom. Let's see if we've noted all the questions and let's see if we've noted all the answers. And then we'll be coming back at exactly 10:30 to continue with our next speaker. And then if it happens that your questions were not answered at our next Q&A, you will be allowed to ask questions from the previous speakers. So rest assured that your questions will be answered irrespective of the previous speakers or the most current, the later speakers. So let's just take a body break for this. Is it 8 minutes now? And then we'll come back at 12:30. Thank you. Okay, I believe everybody's back. We've had our body break, we've had our bathroom, had our smokes. So now it's exactly 10:31 on my time. And as I promised that we'll resume at 10:30. So what's going to be happening now is that we will be going to our next speaker, who is Mr. Sfanele Mathebola, who will be taking us through the adherence to timeline as a professional. So we've touched a little bit on this, but he will elaborate more. And then he will also be taking us through taking over someone's work. So it's also in the code of conduct, what is expected from you as a registered person. And then he will be taking us through what is intellectual property. So he will be explaining all those things to us, and then who does the intellectual property of a plan belongs to. So he will be taking us through that as well. And then also he will take us through performing work while not registered. So just listen carefully. I know it's going to be a lot of information and a lot of new information to say. So just take it slow. If you have to write points down, do that. If you have to note your questions, please do that. Just take it slow for yourself and then try to understand, go with him as he goes through the presentation. So yes, the floor now belongs to Mr. Sfanele Mathebola, who will be taking us through the points that I've just set out. So yeah, enjoy.
Thank you, Program Director. Good morning, colleagues. Thank you for participating in our webinar. I trust that I am audible enough for everyone to participate meaningfully in this webinar. Colleagues and fellow registered persons, perhaps as an introduction to my discussion of this presentation, I need to indicate that the code of conduct which we are discussing today is a code of conduct which every registered person is expected to observe, to respect, and to comply with in full. So if one looks at the provisions of the rules, they sort of indicate that what registered persons must do is mandatory. In other words, registered persons don't have an alternative. They don't have a discretion to exercise when it comes to this code of conduct, but they must do so. This presentation will deal with a couple of rules. These will include Rule 1.3, Rule 2.2, Rule 3.4, 4.4, 4.5, and 4.14. You will notice that in this discussion, some of the rules might have been touched already by my colleagues who presented before. So there is definitely an interlink between these rules and the rules that have been discussed already. So the legal department is seized with the duty of ensuring that all RPs are compliant and they observe the code of conduct in its entirety. From time to time, SECAP does receive complaints from members of the public, which complaints relate to the failure by RPs to perform architectural work for a client within a reasonable time. They also include architectural professionals who use work prepared by other RPs without written authority from the originating registered professionals. And as such, they then infringe intellectual property rights of the originating registered professionals' work. RPs also produce building plans and certain documents of which they are not the bona fide authors thereof. So this presentation seeks to discuss the applicable rules in the Code of Conduct, which relate to the prevalent reported complaints of improper conduct. Just to stress, what informs us to prepare and present on this webinar, we observe that there is a general trend that our registered persons, they often infringe certain rules in the Code of Conduct. So this webinar seeks to address some of these prevalent contraventions that we observe. When it comes to adhering to timelines when performing architectural work, you will note that registered professionals are required to enter into written agreements, which we call contracts. They have to enter into these with their clients. These agreements express terms of the appointment, which include requirements under Rule 4.1A to I of the Code of Conduct. So there is a standardized template of a contract, which my colleagues have already discussed. The purpose of having this standardized contract is to ensure that RPs, when they formulate their contracts, the requirements that have to be observed are in their contract. SECAP does not by any means want RPs to strictly follow or copy our contract as is, but that contract is serving as a guide. From time to time, we do come across contracts which are prepared in a different format and a different style from that which is produced by SECAP, but they have all the elements which are required. And that is precisely what SECAP seeks to do, to ensure that all the required terms of a contract are contained in the documents which are prepared by RPs. So a project, by its nature, is a task to be performed within a particular budget and allocated resources and within a specified time. Therefore, the client professional project agreement for architectural services should provide for timeframes within which the project must be undertaken. There was a question already from one RP regarding what should be deemed to be a reasonable time. So when you do work and you're expected to deliver within a reasonable time, surely the contract, or rather the project itself, must have a start date and a projected finish date. So it is within that period that an RP is expected to have performed their work up to the end and ensure that the clients are satisfied. So sometimes there will be unforeseen circumstances which may prevail, which will then make it impossible for a registered person to adhere to timelines. And the Code of Conduct requires an RP in that instance to make appropriate arrangements to ensure the fulfillment of their professional obligations. In this regard, we have Rule 2.2, which indicates that a registered person should, where reasonably possible, make appropriate arrangements for the fulfillment of their professional obligations in the event of incapacity or absence from work and or inability to perform work. So in practice, we normally observe that there are events that make it impossible for RPs to adhere to timelines. These are incapacity due to illness. So in such situations, it is becoming, it then becomes reasonably expected of a registered person to arrange with another professional to step in and proceed with the work. This is so because clients have their own pressures to finalize their project, and as such, any delay in the project may impact on them negatively in many respects. Registered persons are expected to keep their clients informed in writing about the progress on work undertaken on their behalf within a reasonable time. Clients ought to be informed of any issue which may significantly affect the quality or cost of the project. In this regard, you are referred to Rule 4.14 in the Code of Conduct. My colleague, Kgaugelo Mashile, has already touched on this aspect. She has already indicated that as a way of keeping clients informed and as a way of avoiding having clients reporting you to SECAP, you must keep them informed in every step of the way. If you are submitting plans to council and there are any issues with council, obviously council will communicate with you as a registered professional when you make follow-ups. And then you have a duty then to inform your clients regarding the status of the project. So it often happens that a registered person takes over a project which has already commenced. A registered person may take over another registered person's project where it has commenced. A registered person may take over another registered person's project in instances where a professional arrangement has been reached in terms of Rule 2.2 between the RP and their fellow colleagues, or even in instances where a contract has been terminated for whatever purpose. So it is crucial then for registered persons who take over another registered person's project to act with due skill, diligence, and competence, honesty, and integrity. Registered professionals should not knowingly undertake professional work in circumstances or conditions and terms that would compromise their ability to carry out their responsibilities and fulfill their commitment to clients. So, instances where one would knowingly undertake professional work in circumstances or conditions that would compromise their ability to carry out their responsibilities would be an instance where a registered person is sick or has undergone an operation, but still accepts a responsibility to do work when they know that they are undergoing or they are attending to their health issues. We want to encourage registered persons not to accept work under those circumstances, but rather to arrange and inform members of the public that they are incapable of attending to such work, and rather refer them to other registered persons who may undertake the work. So registered persons who take over and use work which was prepared by another registered professional must do so on the written consent and authority of the originating registered professional. This is in terms of Rule 3.4 of the Code of Conduct. Registered persons are expected to only issue drawings, specifications, and documents in respect to work performed or administered by them or by a person in their employ which bears their names or registration number or the name of the architectural practice. This is in terms of Rule 4.4 of the Code of Conduct. Registered persons are therefore obliged to sign and or identify building plans as having been issued by them if they are the bona fide authors of such plans and where the plans were prepared under their supervision. This will be in terms of Rule 4.5 of the Code of Conduct. So if one looks at the very last point that I have made, that registered persons, they have to sign plans, that is building plans and other documents of which they are the bona fide authors. Essentially takes us to the next point that deals with intellectual property. In other words, if a registered professional signs or claims work to be their own, when in fact that work is not their own and they are not the bona fide authors thereof, they are infringing intellectual property rights of the originator of the work. So intellectual property, what is it? In easy and simple terms, intellectual property is the product of the mind. It is as a result of creativity. An architectural design and a building plan is a great example of intellectual property. Intellectual property laws give individual property rights to their original works so that they may receive remuneration and recognition from their ideas. Intellectual property in South Africa is protected and it may be registered with the Companies and Intellectual Property Commission, that is the CIPC. Once registered, the owner of the invention becomes a right holder and he or she has legal remedies to protect those rights. Fellow registered persons, it is important for you to acknowledge when you are taking work, when you're taking over work which originally doesn't belong to you. You have got to acknowledge the original inventor of the work. You have got to seek written authority or permission to do the work or use the work. If you fail to do that, SECAP may investigate you for improper conduct, and you may be opening yourself up to lawsuits, and you may be taken to task for infringing intellectual property laws of the Republic of South Africa. So the intellectual property, rather, a plan is an intellectual property of the person who draws it or of the person who invents it. So in other words, building plans and designs are the intellectual property of the inventors, the makers, or the designers. To avoid any doubt and potential disputes over the ownership of any intellectual property, registered persons are encouraged to register their intellectual property with the CIPC. Any registered person who infringes the intellectual property rights of another may be prosecuted by SECAP for contravening the Code of Conduct. In this regard, I refer you to Rules 3.4, Rule 4.4, and Rule 4.5. RPs who wish to use other RPs plans and designs must get authority and consent from the originator of the work. So, colleagues, if you see the points that I have discussed above, you will realize that SECAP indeed does have authority to investigate any complaint that have to do with the infringement of intellectual property rights of other RPs. And if you are prosecuted and found guilty, you may be liable to a fine of up to 20,000 rands. In extreme circumstances, your registration might be cancelled or it might be suspended. It will all depend on the circumstances of the case. In other circumstances, you may be cautioned not to repeat the same offense. So that is it with regards to this presentation, colleagues. I will proceed and present on a license to practice architecture. In other words, we will now look at who needs to practice architecture and what happens if one practices architectural work without having been registered.
Okay, before you continue, Mr. Mathebola, I think just for completeness, perhaps maybe we can have the Q&A that relates to the Code of Conduct here, and then we will address the license to practice later on. I'll take directive from Mr. Ntokozo. I think maybe perhaps that will be a better way of approaching it. If we can perhaps do, because now Mr. Matibula will be referring to the Act and not necessarily the Code of Conduct anymore. Perhaps we can have Q&A that addresses the Code of Conduct, and then for completeness, we conclude that part. And then on the license to practice, then it will be a different part of our presentation, because it speaks specifically to the Act and not necessarily the Code of Conduct. So if there are any questions, maybe perhaps Mr. Masango, we can take those. Okay, and then there is before Mr. Masango can go. Before Mr. Masango can go, there is something that Mr. Makakavolo would like to address. Perhaps we should also give him a chance. Ntanganzen, you can go first, and then from there we can hear how many questions or how many hands do we have from Mr. Masango. Thank you.
Thank you. Thank you, Program Director slash Kogele Mashile. So yes, we have noticed from the Q's and A's that there is a lot of questions about CPD for this webinar. So the system will generate the attendance, and then the CPDs will be allocated to registered persons. However, it will only do that where the attendee has attended the webinar for more than 3 hours. So the system will then generate automatically. So all those questions, I'm sure they've been answered, and yes, we'll have one uniform answer for them that the system will generate. You do not need to indicate that you have attended. It will then generate CPD points for you. Thank you.
Thank you, Mr. Makakavule. We'll then take hands. First, we'll allow Don Albert, Antonio da Silva, Francos, Udirile, in that order, please. Don,
Hi
you
there. Thanks, everyone. Yeah, my first question was relating to partnering with international architects, either on local projects or projects outside of South Africa. But assuming they're inside South Africa, surely the local architect can sign off the drawings, you know, without there being any confusion, you know. And then if that is the case, how really does that correlate to another architect, perhaps living in Johannesburg, collaborating with a Cape Town architect, for example?
Okay, thank you for the question. I will, once again, I will be referring to the Code of Conduct. So if you have the Code of Conduct, perhaps you need to go look at Rule 7.2. So Rule 7.2 states that no foreign architectural person shall be authorized to practice architecture in South Africa unless they've applied and been granted registration by SACAP for the duration of that specific contract. So if you want to contract with someone who's not registered here in South Africa, but they're registered somewhere else, what you need to do is that they need to apply and then be granted registration in terms of SACAP for that specific project. So I think maybe perhaps you should just need to go read Rule 7 entirely. Then maybe it will make sense. Thank you.
Mr. Albert, are you covered on that one?
Yeah, I mean, it does get a bit gray, because sometimes the consulting advice that one does receive from overseas people is at a very high level. And in some cases, it might only be really interior design focused. In some cases, it might be more, sort of strategic. So in terms of the reservation of work, I think that the area, honestly, it is a bit gray. But in terms of like production drawings and site instructions and all of that kind of post-contract work, it's obviously it's quite clear the meaning of that clause. I did have another question, which was regarding where were we? It was just a comment about copyright law. For us to have to register every plan that we make in order for it to be protected is not true. We have a moral authority and right against any work that we create, whether it's registered or not, in terms of South African law. So I just wanted to clarify that. Nobody's got time to sit and register drawings with anybody, these things. And half the time, the ones that you have to register are really the very, very early conceptual ones. And, until you actually get a job, you can't be running around doing that.
Okay.
Thank
Yes.
you. Perhaps just to come in briefly there. So the last comment is duly noted. So what we were trying to say is just to ensure, not to say that all registered persons have got to go and register their intellectual property. We're just trying to say, just to ensure that to protect yourself. But obviously, you need not do that if you don't feel the need to. It's not a mandatory thing. It's just the advice. Surely we will not be providing full legal advice on this subject, and perhaps our fellow RPs may then consult legal practitioners who specialize in this field of the law. But it was just to say that just to ensure that you are cushioned, nobody steals your work, nobody steals your ideas. Ideally, that is what should happen. Thank you. Thank you.
Thank you, Mr. Mathebula. Mr. Albert, you covered on that?
Thank you.
Thank you. Can we, Antonio?
Good morning, everyone. I just want to find out something. With the new IDOW change, not allowing professional draftspeople not to do double stories. Okay, I've applied for LSD. I've submitted an LSD application for a whole lot of work that I've done in the past. I'm still waiting for approval on it. Do you by any chance know when this will be done? As I've got work that that I would like to take on. But unfortunately, obviously, I can't carry on until I get approval.
Okay, in terms of that, as I've said in the beginning, I would like to limit our questions to the presentations. But with that, I think perhaps you need to follow up with our registration department to find out how far is your application. So I'll advise you to send an email to info@sacapsa.com and follow up on your application, because at this stage, I won't be able to state how far is your application.
Yeah, I see, because I don't want to contribute my IDOW as well. I mean, that could be obviously.
No, yes, I understand. Because in terms of the code of conduct also, you're not allowed, if you are found to be doing something that is not within your category of registration, it might be a misconduct. So I will urge you to follow up with our registration department.
Okay, all right, thanks.
Okay.
Can we have Francos, then Odirile Musimani next in that order? Francos, you can unmute. Okay, can we have Odirile? Odirile Musimani.
Good morning, everybody. Thank you for the very educational presentation. for myself, I'm interested of intellectual property. Ne? Okay, there's most of the time you find that the client have present like maybe a picture of a project that they saw somewhere, and then they present it to you for you to design. So I just wanted to like maybe understand in terms of acknowledging the designer who did that, and maybe doing away with infringement of the copyright. So like how would we actually like deal with that one? Thank you.
Thank you, Mr. Musimane. Musimane, as a point of departure, it has to be acknowledged that you could find that clients want more or less the same thing. And it is accepted that you could find that the work that you seek to do might have been performed by someone else. But I doubt that it will be the work that you do will be on all fours with the work that has already been prepared by someone else. So when you acknowledge work that has been done by someone else, it would be in instances where you take over a particular project. But when you are starting a project afresh on the instructions of a client, it is highly unlikely that you will know that the same project has been undertaken, the same specifications have been made, and so on and so forth. So in such instances.
Sorry about that, Mr. Matsebula. You may proceed.
Oh, thank you. Thank you, Mr. Masang. So I'm saying in such instances, really, I don't think that anybody would find you to be in the wrong when you carry out instructions from a client who has seen a particular photograph somewhere else, and you merely just draw a plan to meet the requirements of such a client. I hope that answers your question, sir.
Yes, thank you. That answers the question.
Thank you, Mr. Musimane.
Yes, thank you. That answers the question.
Thank you. Can we have
Yes,
Angela, Wayne, and Sitsaba? Angela, you can unmute.
Okay, good morning, everyone. My name is Angela. I'm working in the public sector. I have a question in terms of the issue of copyright. There's a move towards standardization of facilities like clinics and police stations where an architect is commissioned to do a prototype, which is then utilized for many years to build police stations. What I wanted to find out is that is it allowed for the organization to appoint different architects to then implement the prototype once the originator or the original architect does the prototype, but then we commission other architects to then use the prototypes to build around the country. Thank you.
Thank you, Madam. Madam, in a bid to answer your question, I will simply advise that the code of conduct merely requires you to acknowledge the originator of the work. And if you have got to do that very same work, you've got to get written consent from the originator of the work. So it's more of you as a professional acknowledging in the first place that, oh, okay, this work is not my original work, and then acknowledging the original worker, the original inventor, and seeking permission to undertake the same work.
Can I just follow up with a follow-up question on that? If the terms of reference that went out to the architect, the author architect, that prototype will be used for a couple of years to do police stations or clinics. Is that not already unknown to the author that his intellectual property will be utilized? Do we need to do that 5 years down the line? And some of the challenges we find is that probably the author is no longer in practice or has wound down. What do we do in such a scenario?
So your question is, are you expected to repeatedly ask for the same permission over and over again?
Correct.
Well, from top of my head, I think it wouldn't be necessary because the permission would have been sought in the first place and it would have been granted.
Okay. Thank you very much.
Thank you, ma'am.
Thank you. Angela, can we please have Wayne, then Taba, in that order, please.
Right, I don't know if you can hear me clearly.
Loud and clear, Mr. Wayne.
Thank you very much. Where does you mentioned the penalty that was that would be imposed on someone using work that is not theirs and making it out as if it's their design? I think you mentioned something like 25,000 or something like that. Now, we had a situation where an ex-employee used designs, but the fee, obviously, that they receive would far exceed that penalty. Why? So how would that even be considered a deterrent? Your penalty if they're going to be earning a lot more in fees.
Thank you, Wayne.
Thank you.
The sanction that would be imposed by SACAP's disciplinary tribunal is in one or more of the following ways. One, it could be a reprimand. Two, it could be a fine. Three, it could be a suspension of the registration of the offending registered person. And lastly, it would be a cancellation of the registration. So a sanction that will be imposed will be influenced by the merits of each case and the resulting damages that would have been there. The fine that you're speaking of is not the only option available. The tribunal, when persuaded to impose a particular sanction, is more likely going to follow that suggestion. So bear in mind that in extreme circumstances, a registered person may be removed from the role of a registered person. In other words, their registration may be cancelled. And as such, they may not be expected to practice architecture anymore. I hope you are answered, sir.
Right, thank you.
You're welcome, Mr. Wayne. Can we have Taba? Taba, you can unmute.
Yeah, it's Chaba.
Chaba. Oh, please pardon me for that.
Yeah, thank you again for this opportunity. So my question is based on intellectual property rights in alignment with SACAP's mandate to protect the public, right? So in the case of a 10K appointment where the client appoints a contractor, say, to deliver a facility like a school or police station, for example, and then it happens that the client pays the contractor who then subcontracts an architect to produce the design and technical documentation. And then it happens that between the contractor and the architectural professional, there's a fallout, right? And then the architect files for intellectual property rights. Where does that leave the client? Because in this case, you might find that the client has to then reappoint an architect and pay double fees, whereas they've already initially paid for those services.
Thank you, Sam. Sir, in such situations, I think that from the beginning of the contract or of the agreement, the parties must agree what should then happen in the event that the parties no longer see eye to eye. It should be in their contract so that there is no a doubt as to what must then transpire.
Are you covered, Mr. Chaba?
Not quite, but I'll take that answer. Thank you.
All right, thank you so much. Can we then allow Mr. Ray Lamla, then Don Albert, and Ms. Sabi?
Thank you, Chair. Thank you very much. I just want to elaborate on, when we spoke about the contract completion by professionals, it was discussed earlier that we said that every contract should be basically include, the start time and finish time of the contract by professionals. And I fully agree with that. I'm finding that professionals are going to have a serious problem in that regard, because for some reason, all local authorities, and I respectfully use this, that they have illegally gone and split their submission procedures without public comments. By this, I mean what they've done is they've now asked for a two-stage submission. The first one being LUMS, land use management, and the second procedure is the development applications of approval. My first concern here was that the ordinance, LUMS, which falls under the ordinance, does not have a regulated time to consider any applications. And this could be very serious implication affecting professionals, whilst DAA has a 30 or 60 day to consider applications. Just a point that I'd like to raise so that we could see how and what can be done in or included when professionals are basically compiling the contract, because it would be very difficult from the way I see it for somebody to put in a start and finish when the ordinance does not have a deadline. Thank you.
Yes, thank you, sir. So your observation is duly noted. It's indeed a matter that must be looked into. But for what it's worth, in the event that a registered professional encounters problems when they try to discharge their functions, such problems must then be communicated to the client. It takes us back to the discussion that we've already had. Just keep your clients informed to say, look, whilst we acknowledge that we have this timeline within which to finalize this project. However, we've got this and that glitch here and there, so that your clients are kept informed and they understand exactly what is going on in their project. Thank you so much.
Thank you. I think that clears it up. I just particularly brought this up because I want to bring to the awareness of professionals that that the LUMS ordinance, which does not have a start and end time in them considering applications. And I just thought, because we have a large number of attendees today, it might be interesting for them to also make sure they make it the awareness to their clients of this regard. And thank you. I'm happy with your response.
You are welcome, Mr. Ramla. We'll then allow Honorable Vice President, Ms. Sabi.
Good morning, Mr. Masango. Good morning, architectural colleagues. our respected RPs. Okay, Chairperson, I'm just going to go back to the colleague that asked, that made a comment and asked the question about contracting under a contractor on that turnkey project. Now, the chairperson was right regarding the contract. If you just to look at the client architect agreement, it has, if you use that document, it has everything in it as it is to protect your position. Now, in the event that you have a fallout with a contractor, which does happen, because to begin with, it's an unnatural relationship to be appointed by a contractor that you must still try to oversee and keep in line. So that is bound to happen. In that event, now you have your drawings that you did for that project. Now you do have, first remember that you have, by being the author of those drawings, you have intellectual rights over them. Now, when you have a fallout, the contractor and the client need to seek your permission again to use those drawings. Remember, they were paying for the use, but when you are no longer part of that project, you still own intellectual rights. So they need to ask you, do we have permission to continue to use this work? And that's where you have the position to say, no, I was not fully paid. So it's legal opportunities there where you can able to say, no, I need to get as much as I was supposed to have been paid up until a certain stage in order for you to carry on using my drawings or something like that. So that's the position. The copyright always remains with the author. It doesn't have to necessarily have been stamped somewhere in the clouds or wherever, but by you being the author, that is your copyright. All right, then. Thank you. Thank you, Chair. And also, what Mr. Ramlal was also saying now is that, and also Chairperson, that I have found in my practice in the later years. Before, I used to struggle a lot with clients and would get into an unsavory, you're still working with them, but you're unhappy. And I realized it's because I was actually not communicating. And once we started to communicate at least once a week on Fridays, even if it's just one email that is just one sentence saying nothing much happened this week, or this is what we did, that thing helps the relationship tremendously. And you're able to control what you cannot control with the municipalities, because they will definitely they'll bring your name down. So that's how you control that relationship. Thank you, Chair.
Thank you. Thank you for that. That was a mouthful. And now we have Don Albert. Don Albert, you can come in.
Thank you very much. I want to challenge the assumption that seems to be out there that a client can continue in a subsequent stage of the project using the work that you've done for prior stages just because you've been paid for that work. Okay? In terms of copyright law, the ideas vested in the original concept and then in any subsequent further design stages in the project remain the property of the architect concerned, and continue to remain the property of the architect concerned. Now, when we do work in terms of PROXA or in terms of any other normal standard services, the drawings that we produce are intended for that particular time slot. So council drawings are for the purpose of getting council permission. And we stamp on our drawings, not for construction. When we do tender drawings are for the purposes of procurement and eliciting pricing for a job. They are not for construction. And they cannot be used for construction by a client afterwards just because they don't feel like paying your fees anymore. So I would really encourage the profession to be a lot tougher about this with their clients. They cannot just get rid of you because, oh, we've run out of money and we would like to do it alone with the project manager. If they've contracted for a full scope service with you, they cannot wiggle out on the basis of, well, we've paid you for the other stages, so therefore it's okay. There's a termination clause in the PROXA agreement and in most agreements, which allows you compensation for termination if the project is not proceeding. But if they want to proceed with the work that you have done and actually built the reality that you
sorry,
have
Mr.
designed.
Albert. Sorry, can you please mute? I think we are receiving some feedback and we are struggling to hear you. Okay, yes, you can go ahead, Mr. Albert.
Sorry, I don't know how much of that was lost, but my point was that just because a client has paid you for previous work stages does not mean that they can dismiss you and carry on with your work with other architects. That's my point. If they're going to terminate the project because the project cannot proceed, you get paid out a termination clause, but they cannot build off your concept without involving you through all 5 stages if they have in fact contracted you to do that. And I would like to know if there's any case law around this in South Africa, but because you know, I think it's a misconception that you know, you've been paid, so shut up, go away, and we'll just carry on using your work for work stages that it wasn't intended for. Each stage is a scope of work, and the drawings are specifically designed to communicate something at that work stage. You cannot use a council drawing for working drawings or on construction documentation, as far as I'm concerned. I would like some clarity on that from SACAP, please.
Thank you, Mr. Albert. As I always refer to the code of conduct. So I think with that, the answer to what you've just said, it will be Rule 3.4 of our code of conduct. I understand that perhaps members of the public, they tend to use architectural, for instance, they will get a professional architect to come in on the work, and then once they've gotten the plans from the professional architect, then they'll go to a draftsperson to complete the work. So what Rule 3.4 seeks to prevent is that as a registered person, when you take over work, you must ensure, it says that you shall not use architectural work prepared by another registered professional without the written authority from the originating registered professional. So that's what Rule 3.4 seek to prevent. Thank you.
Are you covered in that regard, Mr. Albert?
Okay, let's move on.
Okay, I'll take it as if I'll take it. Mr. Albert is covered. Can we have a Kalalelo? Kalalelo, you can unmute. Hope I'm pronouncing it correctly. Okay, we'll go to Anand.
Thank you. I have two questions. As a result of the law changing, you know, virtually every day, assuming we sign a contract with a client today, and the duration of the project is 2 years, but a year down the line, we end up with a dispute. How do we address it? Is it now applicable on the original contract, or would it be applicable to the contract with its terms and conditions in a year's time? That's question one. Question number two is pirate software or unlicensed software. You know, some people have licensed software, but they employ people maybe in another province to draw up plans, but they are misled into believing that the other person or the draftsman has a licensed copy, and we can come to find out later it's unlicensed. Where do we stand with this in this situation, please? Over and above the service provider for the software.
Okay, thank you for the question. Okay.
Oh, sorry, Program Director. I didn't quite get the last question, but just to try to speak to the first question. Remember that the contract that registered persons are meant to enter into with their clients, Rule 4.1, dictates that these contracts must include, amongst other things, a provision for dispute resolution. So, in other words, the contract must, in the event that there is a dispute arising between the parties to the contract, their first point of reference should be the contract itself under the dispute resolution clause. This resolution clause is the very clause that will tell you what to do, what rights of recourse have you got, and all of those things. So it is important, and we cannot overemphasize this point. It is important that the contracts that are entered into are compliant with the code of conduct for this very purpose. So we need not go ahead, enter into contracts, and then in future when disputes arise, we then don't know what to do. Then we want to come to SACAP to find out what can we do, what can we not do. These things must be in the contract itself, and both parties must have agreed to that. Thank you, Program Director.
Yeah,
the second question, though, I didn't quite get.
All right. No, it was a time question more than anything else, but it's going to take too long to answer, but we can bring it up some other time. In terms of pirate or unlicensed software, right? Let's assume that an architect does work and engages someone else to do the drafting. And that someone else, it could be a student or whoever else, does not have licensed software and may mislead the architect by saying, yes, my software is licensed, but in the meanwhile, it is not licensed, which means the architect has got a licensed one, the draftsperson has an unlicensed one. Where do we stand? Because obviously now the draftsperson is breaking the law. So where do we stand in that respect? Besides the service provider, I don't want to mention any brand names, now clamping down on unlicensed software users. Sorry, is my question clear?
Program Director, may I ask you to...
Can I take that one, Mr. Matiabula?
Okay, sir.
Thank you. Thank you, Mr. Anand, for raising that question. That is one of the area of concern that we've identified, and we are in the process of engaging with the software providers so that we enter into partnership and address that challenge. We've entered into a partnership with Autodesk and also with KEDI, but we want to expand and also address the issue of the piracy with the software use. So it's something that is on the table that we are working on to try to find possible solutions to that.
Thank you.
You're most welcome. Program Director, we have two more hands. We have a hand from Abrahams and also Mr. Ray Ramla. Can we allow Abrahams and then Mr. Ramla?
Yes, thank you.
Good day, all. Can you hear me?
Loud and clear.
Perfect. So I might have one or two questions, or it actually relates to, I think it was Francois that mentioned it early on with the municipalities. So we in Cape Town, we kind of have the same issue. I think I put in the comments as well, where the delays of the plans coming from the municipality. I just want to know, is SACAP, or at what point does SACAP address the municipality? I know they've addressed or mentioned it a few years back that they've spoken to the Joburg municipality, if I'm correct. But Nothing seems to be done from where I'm staying in Cape Town. Nothing's been done from what I could hear. If I can have contact with them on the delay or the approval of building plans. And as mentioned in my comment, the one plan examiner I was spoken to, he was fully stressed out. I mean, like you mentioned to me that he alone was sitting with 75 applications alone. And he doesn't have times to reply to emails, to queries that we might have from through, whether it be through amendments, whether it be through to get information. And one of my questions was, how is SACAP addressing this delay that we are also suffering from our side, as well as the construction industry? And clients are getting frustrated where there's a massive increase in unauthorized work going on because clients can't wait, for example. And then my other question is, I know in Cape Town, we are supposed to submit online, but it's a kind of a two-part question. First thing is, City of Cape Town, for some reason, doesn't update us when things have changed, where the laws have changed or how they process or emails have changed. The other problem I have is that now, before we had direct access, whether it be a direct contact number with the plans examiner, now what the City of Cape Town has done is they've given us one call center number that we dial to. Anybody can pick it up and just goes to this call center. And even if you query this amendment or whatever it is that you're querying, most of the time this person doesn't know how to answer you. And they don't give you the phone number to actually speak to the actual plans examiner who wrote the comments. You have to email him, and as we all know, sometimes an email doesn't describe or really explain everything. You can't type everything on in an email. So it's kind of frustrating in that side as well. So I just want to know if SACAP knows about this. How is these 2-3 questions that I've asked going to be addressed? Because it is frustrating as well. And as I mentioned, clients are getting frustrated and unauthorized work are going ahead because clients can't wait on this whole process. Thank you.
Thank you very much, Mr. Abrams. Through you, Program Director, can I take the question? Can I respond to this one?
Yes,
Thank
I
you.
wanted to hand it over to you, Mr. Masango. Thank you.
All right. No, thanks, Mr. Abrams, for that question. And also to mention that we do engage with various local authorities to address the issue of delay in building plans approval. And City of Cape Town is one of the municipalities that we engaged with. We have a partnership with them. We've signed an MOU, and we have our quarterly meetings in addressing any challenges that are experienced by registered persons submitting plans at the municipality. What I would request you to do is, I'll put my email address on the chat. Please send me all those specific challenges that you are experiencing. Then on our next quarterly meeting with the local authority, we will engage with them on those concerns raised. And yes, the issue of delay in building plans approval, I must mention that we are giving it utmost attention as the regulator. And we have had a meeting with the voluntary associations on trying to get possible way forward on addressing this matter. And what was agreed is that let's proceed on engaging with local authorities on this issue. And if we don't get a way forward, then we can then seek legal advice on the taking the court route in addressing this matter. So it is given maximum attention. So can I then request that you send me all those issues that you mentioned with City of Cape Town? We do have our quarterly meetings with them, and these issues are tabled in that platform, and we then provide you with the feedback on how are they going to address those issues.
Perfect. I'm happy with that. And then just cross my mind. So you'll send me your email address. Yes, then I can do that. I will definitely do that. And then the other question was, or mentioning was, speaking to this plans examiner, they've had 2 or 3 retirements, for example, in their office, and they still haven't replaced them. So now there's a huge backlog. And I can't understand why they're not employing more people to get the process. Surely you want to clear your desk and get things done, but I appreciate it. Thank you. Thank you.
You're most welcome. No, thanks. I've just placed my email on the chat. I will then wait for that email. Thank you.
Thank you so much.
You're most welcome. Mr. Ramla.
Thank you, Chair, and thank you, team. I just wanted to raise an issue with regards to basically how do we actually take into consideration about a copyright plan. It's based on, let's say, Mr. A has drawn a plan, approved, and handed over to client, and the building's passed, and a couple of years down the line, you know, he then approaches another professional who would basically want to do some additions to his home, but he's not going to use the same plan, but he's got to show the same details of the plan that's, you know, in his presence in order to draw these plans. So is there any consequences regarding to the copyright in this regard when a plan is given to you by the registered owners?
Okay. Thank you, Mr. Ramla. That question, I'm sure I've responded to it in the Q&A. So here is let me explain how it is. So when one has been appointed, and as per the contract, one has prepared the plans, and the plans have been approved, and the appointment has been completed. So now A has appointed B to prepare plans in 2020. A prepares plans for B, the plans have been approved, everything is done, right? So when A, so when you A wants to make alterations to the existing approved plans, and he appoints C. C does not need to get permission, right? This is because the appointment has been completed. The reason why we put it there is that we don't want a situation where architectural professionals are taking other professionals' work because of the client having received a lesser quote, and also in terms of the copyright. So it will be copyright wherein you are using someone's design, wherein the design has not been completed, you are using exactly the same things, right? That you have been provided by your client. But then now the plans have been approved, the plans, your appointment is done, and now this person is being appointed on a new appointment, not the initial appointment. You understand? I don't know if you have any follow-up question on that, but I think I've tried to, because I've received when I'm looking through the question and answers here, I've seen that this question is coming up, and registered members are quite let's say confused if it should be, you should request permission. So you can imagine if you have to request permission from someone who built the house 30 years ago, even if they are still alive, but then the plans and the appointment has been completed. So if you're going to be doing a different, if you're going to be appointed on a different scope, you need not to request permission. But then if you're going to be appointed on the same scope, and the appointment has not been completed with that with the initial or the originator of the plans, then that's where it's required. So we'll have to look at the merits carefully to establish if indeed there was if indeed you needed to get permission or not. But as it is on your question, if the plans have been approved and the appointment has been completed, and you are going to be appointed on a new scope, you need not get originating architect. Thank you.
Thank you. I think I'm clear with that, but I just want to bring in a point here. It might be important for the professional when he's signing that contract to do the additional work using a previously approved plan to probably include in his contract that the owner who's come to him now being, a C person, does not owe the previous architect any fees. I think there can become a fee problem, and maybe that's why owners would probably use, a second professional. Thank you. But I'm happy with your answer.
You're most welcome, Mr. Ramlan. Through program director, can we, I don't know, based on your time, can we then take the last 3 hands and then allow the next presentation to go through? You're giving
Yes,
me...
yes, we can do that, Mr. Masang.
All right, thank you. We'll take Council Member Ms. Jennifer Mrembe, and then we take Peter, and then Scott in that order.
Good morning, colleagues, and thank you so much for such a radical discussion. As introduced by Ntokozo, I'm the council member for part of these engagements on SACAP, 6th term. I just want to support our team, the SACAP team, on answering some of the questions. The first one is in terms of software. I would like to suggest that as registered professionals, we too need to play a role in some of these things. For instance, when we hire anyone to do the drafting, we need to ensure that we too ask them whether their software is licensed. Of course, as SACAP, we can do much, but also as registered professionals, it will help if you too do your bit. Ask the draft person that, do you have licensed software? And when you enter into a performance agreement with this draft person, include in there that we take it that your software is approved. I mean, it's legal, it's not copyrighted and so on. The second one is in terms of SACAP, plan approval, especially in the metropolitan areas. Part of the underground work going on is the exploration of coming up with an artificial intelligence program in SACAP, where we can begin to track and trace, but also to improve the speed at which approvals are done, meaning the communication. For instance, you've said in City of Cape Town, sometimes you don't get feedback. So hopefully with this, we can be able to see, first of all, from our side as registered professionals, what is the quality of work that we are submitting to metros, then to municipalities rather. And then from the municipalities part, we'll be able to ask if we can explore the improvement in communication back to registered professionals. I note the comment on the chat where it says it takes about 4 years. What we want to do in this term of office is to see how we can really improve communication. If it's going to take 4 years, then the city needs to say so. But like Ntokozo has said, there are quarterly meetings with the City of Cape Town. But in addition to that, we want to see how nationally, especially in the bigger cities, can we improve the communication? And if it is as bad as it sounds, can we therefore improve the speed of approval of plans? I know that in the, Mr. Abrams, you said, or Architect Abrams, you said, the whole thing about lack of communication, slow approvals, and then obviously don't get feedback, and then professional architects are also losing the work. What we want to see, like Ntokozo had said in the quarterly meetings, even before, once you put it in writing, then we can go back to not just City of Cape Town, but to the big cities to say we are not seeing any improvement at the speed at which plans are being approved. Sorry about the interruption. The last one, Mr. Ramlal, I like that at the end of the question, you actually put some suggestions forward. Okay, I'm just trying to read the chat as well. You put the suggestion forward, but I also want to add on top of what I just want to add on top of what Ntokozo and Tim have indicated, to indicate that there has to be a contract with the client. once the client approaches any registered professional with a plan, or it only makes sense if we also brief the client that there's a procedure, and that client needs to follow procedure. If it's a job that's being taken over, the client needs to be briefed that there's a procedure and law around taking over work, and then we refer to you, Chairperson.
Okay, thank you so much. Thank you for the support, Councillor. And we will take a question from Peter. Peter, you may come in.
Can you hear me?
Yes, we can hear you.
Sorry, I've had my hand raised for quite a while, so I've developed 3 questions. A few of them have been answered, but my first question, coming back to one of the previous comments about the council being held responsibility for complaints. I think as a professional body, we are unfortunately have no voice when it comes to how council, especially I'm talking about the Western Cape, are managing their side of the contract here in terms of the relationship between the architectural profession and the built environment. We have slowly and unfortunately become now the no voice in how building plans are managed at the municipalities, and we are being subject to the mercy of their egos and their ability to do their job and to be managed and to controlled. And I think my comment is not actually requiring a question and answer for it. I think SACAP need to step up and actually start taking more responsibility how council manage their facility, because as professions, we pay a lot of money to be professionals, whether it's through professional indemnity, software, staff, and all these things. And yet it's very quick for clients to say, we are not performing our job, when it is in fact, a lot of the time in this profession, stage 4.1 is causing the biggest issue in the industry in South Africa. It is causing loss of work, it's causing loss of jobs, it's causing loss of income stream for architects and for contractors alike. And I think if anything, SACAP really needs to start stepping up and taking more control of how the councils are being managed. And I'm not the only person that would voice their opinion on this. I think we have become really neglected in the sense that council now are too power driven, and the control of this portal system that we have in the Western Cape has given us zero voice and zero ability to chase them and to hold them accountable. SACAP needs to give us a portal or an avenue where we can start calling these council members out and calling these people out, because they are not doing their job and it is causing us financial burden. So that is my one statement. Then I have 2 questions that I need answered. So sorry, I am quite frustrated about it, because it's causing our industry to be backlogged extensively in terms of moving to stage 4.2, 5, and 6.
Okay.
Stage 3 and 4 of our contracts. I'm also finding that clients, a contract is a 2-way relationship. And as much as we are expected to, be open about how we are going to do our contracts, how does SACAP view stage 3 and stage 4 when it comes to clients over and abusing revisions, in terms of once they start getting quotes from builders and realizing that their Rolls-Royce house that they wanted doesn't quite fit their VW Caddy budget, and we are left doing continuous revisions for people, and when our fees are not being increased, and when we question the clients on them, they said, no, but that's not part of the contract. It's almost open-ended. Is there a format? And this comes back to a previous gentleman's discussion, which I think was very valid. We need to have a more formalized contract system between architects and clients. So if that can be answered, how do we manage this revision story? And then do you want me to go into the third question or answer that one first?
Okay, let me answer the question. In terms of that, I think you need to tailor-make your agreement. There are instances where I've seen agreement that addresses revised work. There will be instances where in your agreement, because in terms of Rule 4.1, it states that you must state the fees payable for your architectural work. So what I would suggest is that perhaps when you state those fees payable, you must state that your work will be revised at a fee if you changes your plan how many times. So I think
Okay.
you just need to tailor make it for it to suit your type of work.
Perfect. Okay, so we have that right in our contracts to do that.
Yes, you can do that.
And then my final question is just something that I've found in the industry, which I'm just trying to understand. How is SACAP managing and controlling companies that are employing architects, specifically draftsmen, to work for them, and they are not under an architectural firm, they are just part of a contractor or a development, or even I've found real estate agents that are employing draftsmen in-house to do work for them, and most of them are getting PR architects, professional registered architects, to sign off the plans. There seems to be a very gray area where they are now being shielded from the public in terms of a contractual a company that is their employer. So, for example, a developer that goes out and does multiple house units and things that hire draftsmen. How does SACAP view this form of employment in terms of, protecting the public? Because there's no responsibility for them should anything come back towards the developer. The architect can raise their hand, or the draftsman can raise their hands and say, well, I'm employed by a contractor or a real estate agent. If you have an issue, take it up with my employer. And there's now a loophole with the code of conduct, because how do you prosecute or take that person to task, because now he's behind a veil of another company?
Yeah, thank you, Peter. Look, I think part of your question was addressed earlier on. If you're there, we spoke about a situation where lower category of registration professionals getting their plans signed by architectural professionals getting signed by professional architect for a fee. So should there be that act which is happening in your eyes, you should inform SACAP that Mr. Professional Architect B is signing off Mr. Draftsperson's work, you understand? Wherein the rule is there where it indicates that you must only sign plans or work that has been prepared by you and or prepared in your office. So if it's not prepared by you and if it's not prepared in your office, you may not sign those plans, because then that will be in contravention of the code of conduct and the respective rule. So in terms of employment and or association, look, all architectural firms or all companies which are performing architectural work, they must be registered, they must be listed with SACAP, right? So once that firm has been listed with SACAP, we will then require that company to indicate to us who are the architectural professionals in that company, and then that company will have to follow another step wherein however they name themselves, that should be as per the code of conduct. So there's one that we can regulate, and there's one that we can't regulate. We cannot regulate who employs who, but then we can regulate who performs what work. Yeah, you understand? So if it is a situation wherein you are saying that the developer is only developing buildings, the architectural work is being done by the registered architectural professional, who will then assume responsibility. So in whatever capacity that they've employed, the code of conduct is clear to say that in whatever capacity that you have been that you're holding, as long as you're performing architectural work, you will then be liable for whatever work that you'll be performing. And I don't know if I should. No, I think this will be reserved for other questions when they are asked. Thank you.
So you're saying that if I'm just going to use this as an example, I'm a builder. My name is Peter. I'm a builder, but I'm getting work and getting a lot of clients requesting architecture work. So now I think it's a good idea that maybe I hire a draftsman, and I get this draftsman to work for me. I employ him, but I'm not an architect. I'm just a builder. Does that company need to now list themselves with SACAP as an employee of that architect, and now that architect is now responsible for everything that happens within that company? And if a dispute arises with the client, because now the client is not contracting the architect, he is contracting the builder to do the work.
Yes.
And he's doing a turnkey project. So that
Yes. No, I understand the question. So yes, if we go back to your statement, a builder is only a builder, and should you, as a builder, this is why I indicated that a company performing architectural work must be listed with SACAP. So let's say
this is not happening.
Peter, now
Unfortunately,
you
this is not happening in
find
this
Tom,
country.
who is a builder.
Mm.
As long as Tom, who is a builder, does not quote architectural fees, then we don't have a problem with that. You understand? So the moment you start quoting architectural fees as a builder, then that is where the problem comes in. We will then have to find out, okay, fine, who is doing this work, right? The person who will be doing that work will be, in terms of the code of conduct, required to inform us of performing architectural work in association with the person who is not registered. So that's why I'm saying that the registered person is the one who is who we have jurisdiction over in terms of the code of conduct. So the code of conduct says that if you are performing architectural work in association with an unregistered person, you must inform SACAP of such association. Wherein on that association, when you inform us, we will then have to question, why are you working with this person? Why is this person not doing what he's supposed to be doing? Then permission will have to be granted or refused.
So my question is, again, I just want to make it very clear. If a developer or a real estate agent or builder or a contractor is employing anybody that's registered with SACAP and is a registered architect, where is it gazetted that company must register with SACAP? Because it is
Peter.
unregulated.
So sorry, Peter, just to avoid the dialogue.
Sure.
Yes, just to avoid the dialogue. I believe that perhaps you can call our office and engage with Mr. Makakavule on this matter. His name is Ntanga Nizeni Makakavule, and then you can call him, and then you guys can engage further.
Perfect. Thank you very much.
Thank you. Do we have any other hand, or should we continue with our program, Mr. Masango?
Hello, can you hear me? Sorry, I was on the list.
Okay, you can go ahead.
Hi, thanks very much. I think I'll be quite quick. My question is just about who owns the CAD drawings when a job is finished? That's basically,
Okay.
that's it. Yeah.
Okay, so let me explain it in this way. The CAD drawings are the intellectual property of the registered professional who prepared the plans. What belongs to the client is the approved plans.
Okay.
The approved plans in PDF format or in hard copy. Those ones are the those ones belong to the client. So the client is getting what they had paid for, and that is what they get. So, but in the CAD drawings, those are your intellectual property. As a professional, you are the one who designed that, and then you can give them to your client on any arrangement, maybe for a fee or whatever, but you are not obliged to give them upon their request.
Okay, brilliant. Thank you very much. That's it.
Thank you, Mr. Makakavule. So I believe now we've come to the end of our Q&A for the Code of Conduct, and then we will then continue with our presentation on the license to practice. I will hand over to Mr. Makakavule to take us through the license to practice. Thank you. Oh, to Mr. Matebula, sorry. Sorry, Mr. Matebula will be taking us through the license to practice. Thank you. As the drill goes, you must listen carefully. If there are any questions, write them down, and then we'll be taking questions thereafter the presentation. Mr. Matebula, the floor is yours.
Thank you, Program Director. Greetings, everybody, once more. I'm back this time around to deal with license to practice. As a starting point, it is important to note that for one to practice architecture, registration as a professional or a candidate is a prerequisite. We have got Section 18 of our Act, which provides us with the various categories of registration. These are 1, professional architect, 2, professional senior architectural technologist, 3, professional architectural, number 2, it's a professional senior architectural technologist, number 3, professional architectural technologist, and a professional architectural draftsperson. And then we have got candidate in the same categories. So Section 18, Subsection 2 of our Act provides that no person may practice in any of the categories contemplated in Subsection 1 until we also have Section 26, subsection 3A, B, and C, as well as D of the Act, which provides that a person who is not registered in terms of the Act may not pretend to be, or in any manner hold or allow themselves or herself to be held out as a registered person, or use the name of a registered person or a name or title referred to in Section 18, or to perform any act indicating or calculated to lead persons to believe that he or she is registered in terms of the Act. So SECAP often receives complaints from members of the public that certain people have accepted mandates to do architectural work. And then when SECAP looks at these people, when SECAP does what we call preliminary investigations, we find that these persons are not actually registered with SECAP. We then refer such cases to the South African Police for investigation. The view is that ultimately such cases must be enrolled in our courts of law, where they'll be ventilated. And if such persons are found guilty of contravening our act, they are then convicted accordingly. So the council is
Program Director, kindly confirm if you can still hear Mr. Mathebula or it's my connectivity.
No, Mr. Mathebula is not clear.
Okay. Mr. Mathebula, can we request that you pause there and
Africa?
try another
This
connection?
is version of I'm still here. Am I hear me now?
Yes, we just lost you for a few seconds there. So can I request that maybe you start afresh on this slide and also try maybe to change the connectivity?
Okay, but am I clearly audible now?
Much better.
Okay, thank you, sir. That SACAP is charged with regulating the architectural profession in the Republic, and that council often is confronted by many difficulties in relation to unregistered persons that are performing architectural work. And this is in contravention of our legislation. So such individuals, they tend to be putting the lives of the public in danger. So SACAP is currently dealing with a number of complaints that are reported by the public that are related to the community being misled by certain individuals that portray themselves as registered architects and offer their services to the public. The fraudulent use of registered professional credentials has been brought into the council's attention as well, and registered persons that are associating themselves with unregistered individuals. Some of these professionals are renting out their credentials for financial gain. I think in the previous discussion, this subject was touched on to actually indicate that there is a prevalence of such a practice amongst the registered professionals. I think that discussion was delved into in detail, and we all know that if a registered professional is conducting themselves in this fashion, they are indeed infringing the code of conduct, and they are subjecting themselves to prosecution by SACAP. So council then deals with such cases in terms of Rule 5.6 of the Code of Conduct. And if the investigation reveals that there is fraudulent activity, the complaints are also referred to the NPA and the SEPS for further investigations. So SACAP and the police, the South African Police Service, did sign a memorandum of understanding. The purpose of that exercise, it was to ensure that those who contravene our legislation are brought to book and that they are prosecuted accordingly. In the past, SACAP has managed to refer over 100 criminal cases to the South African Police Service across the country. As such, arrests were made. Other cases were referred to courts for decisions, and some are already in the court roll. So this is in line with SACAP's mandate, which aims to protect the public. Further complaints include the use of registered persons registrations without their consent. and individuals who are using social media platforms to mislead the public by advertising themselves as registered architects and the fraudulent use of municipal stamps on the plans. There is an investigator who has been appointed by SECAP who conducts preliminary investigations, and it is upon the conclusion of such investigations that the matters are then referred to the South African Police Service. So SACAP is discouraging the public from utilizing services of individuals that are advertising themselves online without due diligence. SACAP does from time to time engage with the South African Police Service, the National Prosecuting Authority, just to get to educate them about our legislation and how to enforce it. Members of the public are also included in these awareness programs, and they are being educated about the importance of verification of the registration status of persons they are appointing for architectural work. SACAP also publishes a list of names of unregistered persons who have been reported to be conducting architectural work without the necessary requirements. The purpose of this list is to alert members of the public about unregistered persons, and therefore they have to ensure that the architectural work is preserved for registered professionals. Colleagues, I think it is worth noting that SACAP does not just publish a list of people who are alleged to be practicing architecture without being registered with SACAP. What SACAP does is it reaches out to such people after receiving information that these people are practicing without being registered. SACAP affords these people an opportunity to respond and actually state their position. Sometimes they revert to us and give us their clear position, and often they do not revert to us, and they leave us with no option but to proceed and publicize their names as an alert to members of the public. So SACAP, in an attempt to close the space of unregistered individuals that are performing architectural work, SACAP has received a complaint against an unregistered person, and the allegations were that a member of the public was referred to the architect by a cousin, and she wanted the services of an architect. The complainant then sometime in 2022 to draw and submit plans to the municipality for approval. An amount of 5,000 rands was paid to the professional for their work. It was approved. However, as to how the plan was approved, it remains unknown to SACAP, because the person who undertook this work was not registered with SACAP. The complainant was not satisfied with the type of work that was presented, and eventually this matter was referred to SACAP and to the police. As a result, this person was taken to court, and he appeared before the magistrate's court for contravening our legislation, and he was later on found guilty, and he was fined an amount of 10,000 rands, and 8,000 of which was suspended for a period of 5 years on condition that this person was not convicted of the same offense again. So it is clear from the foregoing discussion that SACAP does try to prevent unregistered persons from practicing architecture, and members of the public are being educated all around about what they need to do and what their rights are in the event that they are being misled by unregistered persons. That is the end of this presentation, colleagues. Thank you so much.
Thank you so much, Mr. Matebula, for taking us through the license to practice, and then also taking us through what SACAP has done, and also the fact that we have cases that there've been convictions, and we are continuing to make sure that people who are practicing without being registered are being convicted. Okay, I don't know if there are questions, Mr. Masango. If there are hands, perhaps.
Yes, Program Director, we have about 4 hands at the moment. I'll allow them. I'll allow Maya, Angela, Mr. Ramlal, in that order, please.
Good morning, can you guys hear me?
Yes,
Loud
yes,
and
we can.
Okay, thanks. I want to direct a question to SACAP. I have posted it in the Q&A, but I'm going to read it now, as I think it's got correlation to the Code of Conduct. Quite a few times during the session, the terms quality of work and reduced fees seem to be in the discussion based around protecting the public and issues regarding quality and fees. So the Code of Conduct states that we as members should not bring the profession into disrepute. However, currently the profession as a whole is in disrepute and not by actions of the members. Meaning at this time, it would also like to mention that SACAP's mandate to protect the public. So my question is, if the members of the public employs an architect based on rates as opposed to rates and fees as opposed to quality of work, meaning if everybody charges a minimum mandated fee, I'm sure if you're better than the mandated fee or you charge above a certain mandated fee as in the medical profession, that's off your own account. But if there's a minimum mandated fee, clients will not shop fees, but they will shop quality. So what is SACAP going to do to attempt to have a minimum mandated fee reinstated to mitigate this quality or losing work to someone being cheaper? So, and when a minimum mandated fee is reinstated, I mean, this would give some control to SACAP over the quality of work presented to the public. And again, and in a sense, then protecting the public against professionals undercutting and producing bad work. That's my question. Thanks.
Okay. Thank you for your question. So I just want to point to the fact that SACAP has made an attempt, a lot of attempt, in that there is a professional fee guideline that registered persons can use in order to charge their clients. And there's a specific reason why it's a guideline. Because in South Africa, we are governed by the Constitution, of which the Constitution says that everyone has a right of association. So you have a right to choose who you want to associate with. You have a right to choose who do you want to appoint as a professional or as a person to do your plans. So what SACAP has done is that they've done a professional fee guideline that the registered persons need to use when they are charging their clients. So that's why it can only be a professional fee guideline, not necessarily a mandated fee that registered persons must use. So we must also
quite aware of.
Mm-hmm.
I'm well aware of the guideline fees.
Mm-hmm.
My question go beyond that. I mean, sure, there's a guideline fee. You give me an example, or you give me the stats or the majority stats of people being able to charge those fees, because the clients or the public as a whole know that they can just press the prices as far as possible because they can just do it. There's enough of us, there's enough people practicing architecture. So if you will not be able to do it for that fee, someone else will. Yes, it is their choice to who employ or who to go to. But why is it that so many industries have a minimum required fee or a minimum rate, but we, because of the Competition Commission, has been taken out of the equation in terms of minimum mandated fees? And why is SACAP not pushing back to get a minimum fee recommended again? I mean, we've got an identification of work at the moment. That was not on the table when the Competition Commission initially challenged the fee, the recommended fees that turned it eventually into a guideline as opposed to recommended. And the identification of work already caters for different types of work to be taken on. We don't need to take that even further and not have a mandated fee. So that's what I'm saying. It goes beyond that. As a whole, it will protect the profession to have a mandated fee, because currently we are not as respected in the building industry as some of the other professions, because we are just a stepping stone to get a building plan approved, if that does happen, given all the council issues currently. But because we don't have a voice,
Okay, I think I
clients can
understand.
just
Mr. De Beer.
change a fee or...
Hi, Mr. De Beer. I think I got the gist of your question. Well, let me try to answer it in this way. You'll note that we have different categories of registration, right? Which will obviously charge different fees for the work that they're performing. Beside the different type of category category of registration, we also have let's focus on one profession. Let's focus on one category of profession. We have, let's say, a professional architect, for instance, right? A professional architect has there are different ways of charging. Firstly, this is where I want to focus on. A professional architect of 50 years experience will not charge the same as a professional architect of 1 year, right? That being there, we also have a situation wherein the reason why that will be so is that the expertise is known. He has invested a lot on his craft. Even the work that he's going to be doing, he knows what he's going to be doing. The experience that he has obviously informs him about how much he should charge. So what we have is that we have a guideline wherein it indicates the minimum fees. But however, we can't go to a point wherein we're saying that this is it's only a guideline, but it cannot be said that it is what it should be. You understand? Because you must understand and appreciate that the architectural profession, it's not only an academic profession, but also a skill-based profession, wherein there are different skills that you acquire after a certain time.
Thank you, Makakavole. Okay, we will then move to I don't know if he was answered, but I don't see him anymore here. Okay, then we'll move on to the next question. Angela.
Okay, thank you very much. My question is, I have two questions. The first one, I wanted to know whether there's any engagements or agreements between SACAP and public institutions that undertake architectural work in terms of registrations. Do you oversee such organizations to check that they are complying in terms of who is employed or being called an architect and who is practicing? That goes also to municipalities, because it's good enough for professionals to design and apply as competent persons. But the challenge that we find is that the person across on the other side, who is supposed to be checking these drawings, is not competent, does not have the competency, and we get a lot of comments which are just due to the person not being well qualified to understand what we are doing. So I wanted to know what measures are being taken to ensure that the institutions that are approving and the clients who are undertaking work and are having internal technical persons also comply in terms of who they're employing and who they are giving the mandate to undertake architectural work. Thank you very much.
Okay. Okay, thank you for that question. And also just to emphasize that we as SECAP, we are a regulatory body that regulate architects, and we regulate registered persons, which are individuals. So I'm not sure if there have been an engagement from SACAP in terms of public sectors and so forth, but there's been an engagement with SACAP with the municipalities. So that's what I can say for now, that there's been an engagement from SACAP with municipalities. As for public sectors, I won't be able to say now. We will have to engage Mr. Masango, our stakeholder relation, to find out if there's been any engagement with the public sectors. Thank you. I hope you are answered, Angela.
I'm not answered, because I just wanted to find out, if not, is there any way, because that brings a lot of challenges in that the professions, and brings frustrations, being in a lot of enforcement is being done in private sector. But similar, I know there's a CBE which should be overseeing and having these engagements. But how far and what is being done is critical, because a huge portfolio of infrastructure sits with public sector. And sometimes the public sector wants to do these projects in-house. So that is a gap that I think SACAP needs to look into.
Okay, thank you so much for that point. We will engage further with our stakeholder relation. So perhaps maybe you can just, his email address is on the chat. Maybe you can just email him and then we can engage further. But thank you so much for bringing that up. Thank you.
Thank you very much.
Mr. Ray Ramlal.
Thank you, Chair. I want to actually compliment you and the team for an excellent presentation today. I think it was thoroughly enjoyed by those that attended. I just have two quick questions that I'd like to end off with. Earlier, we spoke about online advertising. I just want to get clarity as to when a professional basically completes a plan, and before or after it's approved, and if that professional then puts on a site notice, a construction notice, where his names appear on the construction notice with the various engineers and other specialists who's on there. Is that called advertising that's not allowed, or is that allowed? You know, it's on a particular site where plans have been approved. That's my first question. And just for the, I know we have over 14,000, professionals in SACAP, and I would just like SACAP to just highlight that today's code of conduct, I see you don't have so many attending. Will SACAP be assisting the other professionals who didn't attend and possibly publish this on your website of today's hearing? That's all I have to say. Thank you.
Thank you. For your first question, I just want to refer you to Rule 3.1, which states that the registered person may only communicate and promote themselves and their professional service with honesty, describing both in a manner that is related only to the work of the professional category of registration presented in a practice. So it means when you are communicating, irrespective of where you're communicating, you must always be honest. So I'll just refer you to Rule 3.1. In terms of how we are going to present and help others who are not in attendance, this webinar will be, the recorded version of it will be on our YouTube channel on YouTube under SACAP SA. So you can go search for it there, it will be available. Thank you.
Yeah, thank you. You and the team, you have actually done very well today. I think today's presentation was very informative, and as I speak on behalf of, supporting the profession and making sure, everybody is in line with the practice, I compliment you for handling today's presentation and your team in a very good fashion. Thank you very much.
We thank you also. Thank you. The next question is from, I don't know if I'll say your name right. It's yes, start with the VVI.
Yes. Just call me Anand, that's fine. Anand actually means happiness in Hindi.
Okay, thank you.
Right, but you can call me, actually it could be Jabulani, but you can call me Jabu.
Okay, no, the floor is yours, Jabulani.
Thank you. Okay, if I employ a draftsman who's not registered with SACAP, just to do some drawings, is he allowed to put his name on the drawing, for example, drawn by? If he did all the drafting, but he's not registered with SACAP or applying to SACAP, but not currently registered, would he be would he or I be allowed to put his name down as drawn by on the plans?
Okay, I'll refer you to Rule 5.6 of the Code of Conduct. It's saying that if you want to do any architectural work with someone who's not registered, you must first seek permission from SACAP. So if you have sought, yes, so if you have sought permission from SACAP to work with someone who's not registered, and then you've got that permission, then you can list that person on the plan and say drawn by. But if you have not, if you don't have that permission, you're not even supposed to be working with someone who's not registered.
Okay, thank you very much. Short and sweet, and thank you very much, team. You've done an excellent job. I agree with Mr. Ramlal. And yes, maybe still continue with what you're doing in the various categories. By the way, I was approached by Ricky Mudley as well to try and assist with on the educational side, only because I've been practicing for 54 years, just to try and give my input. I also mentor architectural students, and I would like to share, like the older people would, only because I have a variety of, projects I've worked on with various companies and on my own, for example, Sun City, FNB Stadium, Checkers projects, or General Tower, and so on. But we leave that for another time.
Yes, thank you. Thank you so much for attending, Jabulan. Then we'll move to Bram. Bram, the floor is yours.
Thank you. Good morning, everyone. I just have a question. I think it's probably related a bit to both, but more to the legislation part. Obviously, us as professionals are required to register, and then we are limited by the identification, or not limited, but we are required to adhere to the identification of work framework in terms of work that we are allowed to do. I have previously and more recently again encountered where certain residential estates still limit the category of professionals who are permitted to perform work in their estates. This even after the circular published in 2022 at the joint statement by SACAP and the Competitions Commissions. Because I still, at the beginning of the year, I was approached by someone to assist them with drawings within a residential estate, and the architectural guidelines published by the estate states that only professional architects are permitted or allowed to perform work in the estate. Is there any way to get past that? Can a person report them? Is it legal for them to limit us or to limit the category that are permitted to perform work in their estates, whilst we are allowed, in terms of our professional registration and the identification of work framework, to perform the specific work that is being done in these estates?
Okay. Thank you for that question. So what SACAP has been doing is that whenever there's such a complaint, SACAP has been reaching out to those estates, and then most of those estates were able to amend their estate guidelines. So what you need to do is you need to email us at legal@sacapsa.com to give us details so that we can reach out to that estate and find out their reasons, and also point them out to the identification of work, and then hopefully they will change their guidelines, because we are very strongly driving that. And then we have had many estates that have actually revised their guidelines. So just bring it to our attention with the specifics, and then we'll address it. Thank you.
Thank you very much.
Program Director, just in addition to what you have just put forward, let the RPs be aware that indeed SACAP is taking these matters seriously. As I speak, there is a pending court case surrounding this issue. So what we then seek to do is the outcome of that case will surely be communicated to everyone, so that people can begin to appreciate that undermining the identification of work, as well as the Competition Act, is something that SACAP is frowning upon, and legal action is duly taken in such instances. Thank you so much, Program Director.
Thank you very much.
Thank you. Just to spell out the email address, it's legal@sacapsa.com. So you can just write that down so that you can send us an email. Thank you.
Thank you very much.
Okay, and then we'll go to Jennifer. Jennifer, the floor is yours.
Thank you so much, Chairperson. Thanks to the team, and thanks to the compliments from the attendees. I'm just going to add some of the answers, right? I'll start with Architect Mayor De Beer. You indicated around the fees. I think also, in addition to what the team has said, allow us to go back to the board and see how much can actually be mandatory. I understand that while there are architects on the higher end who can charge whatever, but also there are architects at entry level who need that mandate fee so that they can quote or tell the client that, no, this is according to the Architecture Act or according to SACAP, that there's a minimum fee that you need to pay. I think just allow us to go back and just see, is this possible, and how much? Obviously, this will be done in consultation with the architectural fraternity to just see how much would be like the minimum mandatory fee, because that's what actually would protect the entry level or middle architects, quote unquote. Then, Angela, your question on whether SACAP is overseeing the employment of architects in public institutions, that goes beyond our mandate, because when adverts go out, I understand that you're probably talking about architects employed by government, for instance. When the adverts go out for employment, it is, for instance, the government of Western Cape advertises for architects. If you look at some of the local municipalities, they have been advertising for architects to join them. Now, it is SACAP cannot now go to government of Western Cape and say, no, but let's just check whether the architect is competent that you're employing, because public institutions follow the seal and the registration number of the architect. So if the person employed is registered and their registration number is still valid, that's what the public institutions follow. However, in line with your complaint or your question, I think what we need to pay attention to is if yourselves who are engaging, for instance, if this architect is in charge of overseeing all the building designs in the Western Cape province, and then there's a problem there, maybe what as an area of growth is if there are constant complaints about the competence of that particular architect, then that needs to come to SACAP on the emails that are in the chat. Other than that, governments and other public institutions follow the registration number of the architect. That's how architects get employed. And there's also a performance agreement in terms of employment. So if that architect is in charge of scrutinizing other designs that are submitted by other architects in private sector, that's what they do. And their role is to ensure that they also protect the interests of that public institution. For instance, if that public institution is looking for a particular design or whatever, that's what they look for. If there's a budget attached to that, a minimum of, let's say, 300,000 per unit, that's what it is. So that architect also has a performance agreement with a public institution, and that's what they follow. I just want to also contribute to Mr. Ramlal's question about advertising. The issue of putting your name on a board with all the other built environment professionals, the engineers and so on a construction site, part of that is actually law, especially in construction in estates. But I also see that a lot in government projects where you actually have your name. It's required that your name is on the billboard, as well as whether the contractor has an NHBRC registration, the registration number, as well as the engineers and so on. I think part of what we were saying in the session when it comes to social media, and I think that Tim has answered that very well in terms of whatever you put on social media about what your practice has done, it should be honestly have done by your practice. Of course, with social media, it's quite slippery because you find that it's easy to talk about a building or another person's project and so on. Now that's where it comes a contravention. If you have not sought permission from the author or original architect. So in terms of Rule 3.1, it is. Whether, of course, when you do work, you will put it on your social media platforms, but it has to be honest. It was done by you, your profile, and so on. It must have done by yourselves, and you can account for it. You're not talking about another practice's work. Now, in terms of after this, where the work is going, it's already live on Facebook. And it will be recorded. I mean, when you go to Facebook tomorrow, you will still find this recording, but it's also going to be on YouTube, like the team has indicated. It's going to be on LinkedIn. We're trying to get it on Twitter, TikTok, and still running on Facebook. So as part of our term as well, we look forward to going wider on social media and more frequent. When you see our posts, please share. On a lighter note, we'd like to go viral. Then in terms of VVI or Jabu, your question was in terms of employing a draftsman who's not registered by SACAP. Indeed, we as SACAP also expect the registered professional to take responsibility for this. Therefore, it is safer if the RP's name and privy seal is on the drawing, because should anything go wrong, the back stops with you. Last question in terms of BRAM and identification of work, like the team has rightfully indicated, estates have been some of the estates where this has happened, the attention has been brought to them that there is now an identification of work framework, but for those who do not have it yet, you can also help SACAP by bringing this to attention of SACAP on the emails in the chat, and this estate will be brought to book to indicate that we now have an IDOW framework, and they need to update their terms of who can design in the estate. Back to you, Chairperson. Thank you so much.
Thank you. Thank you so much. We will move to Robert. Yes, because we actually have 15 minutes left. So let's just keep our question brief, and then we'll move to Robert. Robert, the floor is yours.
Thank you very much. And I'll keep it very brief. I'm just I'm piggybacking on two previous comments. The one by Angela about appropriate experience and qualification. It is not just at the municipalities. but is that institutions like the Heritage Resource Agencies, AMAFA and so forth, their staff, not one of them has got an architectural qualification, not even a 3-year degree. How are such people supposed to do assessments of heritage applications? This is a subject that I think you should be taking up with the Heritage Resource Agencies. They may have a history degree or diploma, but not one of them has got an architectural qualification. And these people are having significant effect and input onto a lot of important designs. And then my second one was the speaker who spoke previously to Angela about the minimum fees. Now, I'm an old codger. I'm in my 70s. I've been working as an architect for 40 years, 50 years, and I remember the days when you had a minimum fee. You could go over it, but you couldn't go under it. And yes, there were hyenas in our profession who would go under it. But the one thing for sure was that you wouldn't get the situation which we had recently, where a peer of mine was sitting at a Heritage Committee meeting where the award of a tender was announced. And the person said, "Oh my God, not really. We entered it solo, hoping that we wouldn't get the job. We're never going to be able to do the job for this price." Now, what happens in those circumstances is that you will do as much work as your fees will allow, and then you will drop the ball. And this happens time and time and time again. I cannot tell you from, well, I can tell you from my aged perspective that there should be minimum fees so that for the amount of work that's required, this is what you should be charging, irrespective of whether you like it or not. You can always up your fees, but you shouldn't be doing below because you can't actually make it pay. That's all I want to say. Thanks.
Thank you, Robert. What we'll do is, because we have a professional fee committee that looks at the professional fee guideline, we will take this to them and then they will do their own research, and then there will be feedback once the professional fee guideline is published, because it's published every year. So, but thank you so much for your comments. We are noting them down.
They're welcome to contact me. Thank you and have a nice day.
Thank you. Thank you. We are noting your name as well. Thank you. Thank
Through
you
you,
so much.
Chairperson.
Yes.
Through you, Chairperson. I think since Robert is referring to me, Robert, my name is Jennifer. Okay. I just want to indicate that in terms of the Heritage Resource Agencies, I think that is good that you've brought it up. I think what we need to do is that you bring it to the attention of SECAP, like you've done it now, so that SECAP and the different relevant committee can actually let these agencies know that for certain jobs, actually, certain jobs require a certain registration. Government also did that. If you look at the history of employment of specific specialized skills in government, you'll see that at some point about 6 or 7 years ago, certain jobs were ring-fenced for registered professionals. Whether you're an engineer, you had to be registered in a certain category. So thanks for bringing this up. And I think we need to carry out the same campaign to such as the Heritage Resource Agency. Thank you so much.
Thank you, Jennifer. Then we'll, yes, thank you so much. Then we'll move to the last question, the last hand, perhaps. Ms. Zabi, the floor is yours.
Thank you, Chair. Chair, mine is not a question, but I'll first just go back to this last comment regarding about fees. Okay, so in SECAP, I sit as a chairperson of the professional fees, and what I can tell you is that we're going to be looking at different types of charging and then try to bring that into the gazetted fees. So we'll be doing some certain workshops because we know there are colleagues that are charging square meter rates, and there's also some colleagues that have started charging task-based fees. Task-based fees, those are ones like an itemized list. So you'll find that if you really sit down and you think about each and every single activity that you're going to be doing on a project, it might even come up to 300. But all of those, they actually do have they equate to time, and time there is an hourly rate, and you'll be able to do that. So those are the things that we're going to be looking into. So when that time comes and we wish for your participation and contribution, we hope you will come through to help us to build these so that we're able to help all the different RP offices in different ways of charging, and you're able to choose what works best for you. And then I appreciate the comment by my counselor colleague, Ms. Jennifer there, when you're talking about social media. So just to even summarize it, on social media, you just give credit to the author. If you're going to put somebody's work, just credit it. If it's your work, you credit what you contributed in that part. And what I can tell you about the fact that Competitions Commission has a say in our fees. What we managed to fight to get to this point, they were saying to us, now listen to this, they were saying, why should you even have a fee guideline to begin with? Why should it not be a willing buyer, willing seller? And we actually had to go there with a huge pack of residential plans to painstakingly and educate them through each and every single component of what it takes to compile and create a house. And they appreciated to see that. And then they saw, oh goodness, no, of course, I cannot expect this amount of work and then have paid somebody who and hope to get this for 5,000 rands. So they got to actually see. And that's when they allowed SECAP, okay, guys, go ahead and have your guideline fees. We understand that it is a guideline, because our thinking is that in the absence of a guideline, it means there's going to be chaos. It means there's nothing that you can use as an RP to a client that, you know what, actually you should be paying me 200,000, but I've discounted it for you and you can give me 120 because you feel that's what you should be getting. And then my fellow beloved RP colleagues, you see, I call you colleagues because I'm also a practitioner and I run a practice. I will tell you that as soon as I started to really use the client architect agreement as it is, as strange as it seems, you feel like 17 long pages of ongoing legal jargon, but I tell you, that thing protects you in each and every single way. So the more you're acquainted with it and the more you put it in front of your client, is the more they're going to take you seriously. And in practice, as soon as I started doing that a couple of years ago, one starts to also feel the confidence to charge more towards the fees you want. When there was a time you would have charged 25,000 rands for a house, you find that now you're charging almost 300,000, and then 400,000, and there will be clients who will take that. So when it comes to charging fees, I think there's a choice. If chairperson, if our colleagues can understand that, if we all just decide in this group, how many are we, chair, today? How many are we, chair?
Now it's 791 people.
Okay, thank you. Thanks, Chair. Now, if now 700 is a huge, it's a huge number. I mean, I don't know how, I can't remember how many we are. It's almost about 7% of the registered people in SECAP. Now, if we all decided that we are just going to up our fees to what we feel the value of our work is, it means we are starting to move the pendulum. The pendulum has to be moved from all of us in our individual offices, and a client will pay you. They will pay you, because there have been clients who will come to our practice and they say, we use somebody we got in trouble with 3 people that were charging 20,000 and I was charging 15, and then you take on their work and then you say, well, I'm going to do this for 170,000, and then they go with you, but they already failed 3 times because just charging those fees is just not sustainable for you. You have a right to earn money. It is your God-given right. But at the same time, you're protecting the client because now you're excited to do the work at your desk and you're going to give your client the best. So Chairperson, that is all I wanted to say to our colleagues. Ms. Mashilo, you and your team are leading this exceptionally well. This is the internal SACAP legal staff. It's amazing how they know us so well, but we just need to take control of charging and use the client architect agreement. It's very, very impressive to your clients. Thank you so much, Chair.
Thank you. Thank you so much.
Chairperson?
Thank you so much. We are actually running out of time. We're going to be cut off.
No, Chair. Just 1 minute.
Okay.
Thank you, Chairperson. I just felt this is important. It's important for the audience to know that the previous speaker is actually the Vice President of SACAP, just throwing it in there, so we all know. Before we get cut off in a second, also just to emphasize, one of the things that our council, the Sixth Term Council, wants to do is that we want to make sure that we as architects are so proud of our profession and we have confidence in it. And we know that this is actually the go-to profession. So if all of us can believe it and be so proud of it, then we will be entirely sure that when we do charge, like Vice President has indicated, we will actually get paid. We will say no to free work, right? Thank you so much, Chairperson. I just wanted to acknowledge Vice President in her capacity. Thank you so much. Back to you.
Thank you. Thank you so much. Thank you so much. That will be the end of our Q&A. Thank you so much for your participation. And thank you so much for the support that we've received from each and every one of you. And then thank you so much from our council members for attending and showing us support. We are very thankful to you. And we believe that we've made you proud. And we believe that by this webinar, there will be less complaints because now registered persons are going to be aware of the code of conduct, and then they're going to be aware of the rules that are being contravened, and then they're going to avoid to contravene those rules. Thank you so much for your patience. Thank you so much for taking notes, and thank you so much for listening. And then now we'll go to our vote of thanks and closure. And then I think this will be the last time you're hearing from me, because after the vote of thanks and closure, this webinar will be closed. Let me just show my face. So thank you so much for your attendance. Then I will give the vote of thanks and closure to Mr. Masango to conclude our webinar. Thank you so much for your attendance once again. Thank you.
Thank you very much, Program Director. I think as we come to the closure of the webinar on the importance of professional conduct and adherence to ethical standard in our profession, we would like to extend our sincere gratitude to all RPs who attended and all behind the scene team, our IT team, SR team for organizing the session, and the insight shared by our panelists, Ms. Mashile, Mr. Makakabule, Mr. Matebula, have undoubtedly enriched our understanding and provided valuable guidance for upholding ethical standards and professionalism in our profession. And also to thank our council members who joined us, Vice President, Ms. Shongwe, and Ms. Mirembe, we appreciate your support. So as we go back to our workstation, let us apply the knowledge gained today in our daily practice to ensure the high standards of professionalism by adhering to the code of conduct And with those words, we then call this webinar closed. I thank you all. Thank you.
Thank you, Chair. Thank you, RPs. Thank you, colleagues. Bye-bye, everybody.
Thank you. Thank you.